Petition on Friday, Your Lordships directed it should be listed today. It's not been listed. The matter was numbered on Friday itself. I made sure of that. It's still not listed today, Your Lordship. Despite Your Lordship's directions to that effect.
So now go on Friday only.
Your Lordship, on Thursday then. Friday is a holiday.
Thursday.
Please, Your Lordship, may kindly direct for Thursday then.
Miscellaneous.
Please, Your Lordship. Obliged.
My Lords, with your Lordship's permission, just 1 minute. Two matters which are of some urgent moment. The first one regards these demolitions which are supposed to commence in Gurgaon right now, regarding a High Court order which had nothing, no direction regarding demolitions, nothing of any sort. It was only regarding the stilt +4, whether it's permissible or not. The High Court had passed an injunction saying, no, you should stick to the old policy. That's all it was. Purportedly based on that, directions have been issued by the local authority in Gurgaon that you go into each of the streets and start demolishing.
Clarification you seek from the High Court, Mr. Gopal.
Well, the problem is the demolition are happening now, so we have filed an SLP.
If the High Court interim order is being misconstrued by the authority,
Yes,
the best for authority.
but now we have filed the SLP, my lords, as of yesterday. Urgently, we
SLP means that you are agreed by the High Court order.
because the interpretation that the authorities are giving is that.
That interpretation you seek from the High Court.
Could I then just be given a small protection, because right now no notices at all, but demolitions are taking place of our compound walls. Trees are going in. Yes.
So these are all unauthorized construction.
Yes. Even then a notice.
In Gurgaon, who knows? We have a little fair idea.
Yes.
If High Court in its really constitutional duty,
Yes.
taking a drive to stop or prevent or
Yes.
dismantle
If they did that,
construction,
yes.
then as apex body, we should why we should cause hindrance in the High Court?
I agree. This is not asking for a hindrance to be caused to the High Court, because the High Court never said anything about demolition. High Court did not. The problem is misconstruing that right now without any notices to any individual. Your Lordship's orders regarding demolition,
High Court, then.
bringing in. Then will your Lordships do me the small indulgence, my lords, of granting me just 4 days status quo? I'll go to the High Court.
Go to High Court, please. High Court fully is open.
No, but the demolition is happening from 9 a.m. today, my lords. Demolition is happening from 9 a.m. today. We had filed it yesterday, urgently mentioned before the registrar.
Our online order can create a lot of complications.
No, I'm saying just for 3 days. Just 3 days, give me a status quo, my lords.
Why can't this prayer be mentioned before the High Court 10 o'clock when the bench set?
Because the Supreme Court orders have come from the earlier 2 rounds, have come to this court. Another bench has dealt with it. They have defined what is the scope of the interim order that can be passed by the High Court. That's why we came here, my lords. Would your Lordship just grant me the indulgence of just 3 days status quo? Because in demolition matters, your Lordship.
You must be, most of them are builders. And
No. We are individual residents. Your Lordship may see copies of the petition. I have photos. There are children standing at the door while the JCB comes in and starts demolishing slopes from outside, demolishing walls. Trees are being brought down. It's happening right outside their compound walls and on their compound walls without a notice. These are completely legal constructions.
High Court, you can make a mention. We'll permit to say on oral mentioning.
Yes.
On oral mentioning, the matter is taken on board, especially petitioner being against an interim order are disposed of with liberty to the petitioners to make a urgent mentioning before the High Court during the course of day. We request Hon'ble Chief Justice to entertain the oral mentioning either at 1 o'clock
Very well.
or immediate after lunch at 1:45 p.m.
No, I'm grateful. I can't ask for more than that.
That will help you.
I'm grateful. That's all I can ask. I'm sorry, Mr. Lahoti. There was a second mentioning, that All India Judges matter. There are some All India Judges matter over the e-courts management. To be fair, about 14 states have complied, about 11 are still left. Whenever it's possible, if your Lordship can list it. That's a 3-judge bench matter, if your Lordship.
That is to take on.
Yes.
We'll fix it.
Very well. I'm grateful.
We'll notify that one.
Very well. I'm grateful.
Our party will see what can be done.
My lords, I am seeking permission to file status report, my lords, in Gurgaon matter where SIT was constituted, my lords. SIT has completed the investigation, my lords, and I want to file this status report, my lords.
Illegal.
My lords.
Gurgaon matter.
Yes, my lords. SIT has completed the investigation, my lords.
State in the matter.
My lords.
Is it listed today?
No, my lords. It's on 11th, my lords. But we were earlier given time to.
Investigation is complete.
Yes, my lords.
Have you filed charge sheet?
My lord, charge sheet has not been filed because this is the status report of the SIT.
Don't seek any approval. We don't want to. Madam, Secretary, here.
Please, my lords.
It may not be appropriate for us now to comment on charge. If
Please,
you
madam.
have completed investigation
Yes, my lord.
and you are satisfied, the SIT is satisfied, then you go ahead with the filing of it. Or you want, because if we say and comment on it, it won't be appropriate.
My lords had directed us this to be filed, so your lordship may consider this or take this on record and permit us to proceed, my lords.
Now is it complete or not?
Yes, my lords,
Charge
SIT
sheet
has
ready.
completed.
So we can say then upon mentioning the matter is taken on board.
But my lords, we have not informed the petitioners, then maybe we should mention it with their,
This is the matter where Mr. Rotgi appears.
Mr. Rodki appears.
He is appearing pro bono in that.
Yes, my lords, so. My lords, we'll come back and mention, my lords.
Or why don't you do one thing? You go ahead with your charge sheet
Please, my lords.
and then file an affidavit that investigation is complete, charge sheet has been filed.
My lords may just permit us to place this on record today, and I'll advise the SIT that they can proceed with the charge sheet, my lords.
Or let's say, on all mentioning the investigation report contained in a sealed envelope is permitted to be handed over to registrar judicial. Post the main case also. Is there any date in the main case?
11th May.
My lord's permission, my lord.
The same shall be tagged with the paper book for being the main with the paper book as the main case is coming for hearing on 7th and main case to come up on the date fixed, that is 7th May 20.
11th, my lords.
11th May, my lords.
11th.
11th May. 11th May.
My lords, would your lordships also observe that SIT is free to proceed in accordance with law, my lords? Lordships.
My lord's permission, my lord. Illegal. In Amrapal, if your lordship won't mind it, there is some
We'll
urgent.
see, please. There are other
With your
things more important than
My lord, illegal detention.
With your lordship's permission, may I mention, my lord, a matter, my lord?
My lord.
item 62.
May I mention?
Your lordship.
Some,
No mentioning, please give your
My lord, illegal.
mine is slightly peculiar, my lord.
66 days, my lord, he's in a jail, my lord. Since 66 days, my lord, I'll mention, I filed on the 1st April, my lord.
Why can't you hand over? Why with the need of?
Yes,
you are saying
madam.
that you hand over.
Lord, mine is
Already
slightly
there's a-
peculiar if I
My lord,
be given
there's a-
liberty.
Yes, your lordship.
My lord, 66 days, my lord, there is a since custody, my lord. I mentioned,
Asking about integrity. I mean, these are
my lord, already I mentioned that.
that we send our clerk. May I just pass on this email?
Madam, despite God gifted voice with you, but we can't hear you unless you use the mic.
My lord, since 66 days, my lord, he is under custody, my lord. And the police is taking custody and they're dragging intentionally, my lord. My lord, due to the influence, my lord. Much obliged, lordship.
Sorry to interrupt, my lord. My friend doesn't mind, lord. I've been trying to make a request. Mine is slightly peculiar, my lord. This is those batch of matters, my lords, pertaining to validity of that online gaming. Online gaming prohibition. 22nd, my lords, now they have enforced the act with effect from 1st May. The reason I'm saying peculiar, my lords, the matters are technically on board, my lords, in the alternate bench. Because that may take time because lordship is busy in the 9 judges, my lord. Only requesting if some date to fix for directions, that may be taken up whenever it's convenient. But if the matter could be just fixed for directions, your lordship may have an opportunity to
What is the
fix
urgency?
a schedule of hearing, my lord.
Online game. What is the urgency in this matter?
Lords, our business, my lord, we are virtually
Let it
on
go.
the street
Your
now, my lord.
business.
From 700 employees, we are down to 50, 60 employees, my lord.
Online gaming.
Completely wiped out, my lord.
700. Then you are running a racket of gambling.
No, mine is, I'm rummy, I'm a game of skill, I'm not in those poker and all those people, my lord. Mine is a different
We will see,
category.
there is no urgency, we will see what is, when to be listed.
Lordship.
Yes, your lordship.
Lordship, as I had mentioned, this is IA number 114890 of 2026 in the Bar Council matter, your Lordship, Yog Maya matter. The IA was filed, there were defects were cured. I've been doing this for the past 29 years. Now the latest defect is that come and explain what is the maintainability of an IA. Is the registry supposed to ask us? Writ petition I can understand, where there is a local stand in a IA it cannot be, Lordship. They see to it that matters are not listed. May I just pass it on? Just pass this on to Madam.
तो 11 बजे पहले पानी पीने को बैन Done, madam.
The
Thank you.
registry is harassing the advocate on records.
Thank you very much. We will see what is to be done.
Yes, your lordship, finally has been.
Lordship,
Yes, item 62, please.
Yes, your lordship. Your lordship, this is a very serious concern of a lady officer of the court, your lordship, has been assaulted, your lordship.
Find out what
A
is.
lady lawyer. Your lordship, this is I have made one-page note, your lordship, of how the sequence has been, have occurred, your lordship. She has been stabbed, brutally stabbed at the offices of husband, and she has been locked out. And then after somehow she could able to manage and give a phone call to PCR and her brother. And after that, she has been gone to 3 hospitals where they have been refused to entertain her, saying that it is a critical, so we cannot, your lordship, court master ji, aap ek
Those which I prepared in the, on the basis of which is to be taken.
court master ji, please. Your lordship, this is a fact, your lordship. In my letter, your lordship, I have given only the gist. And now I'm able to get the facts, detailed facts, your lordship.
Let us
Yes.
examine, we understand that part. That's the reason that yesterday, the moment I received your complaint, immediately I closed this
So
home.
bless your lordship of
Now, what is
making
its
it.
status, madam?
Malad, I have found out, Malad, the accused was arrested in the intervening night of 25th, 26th,
Has the
yesterday.
accused been arrested?
Yes, Malad, he has been arrested.
Accused is husband of this.
Husband of
Victim.
the victim, Malad, and he has been arrested, Malad, he has been remanded, Malad. And the IO is here with the file. I called for the file, Malad, if your lordships do wish to say. In AIMS, she was treated, Malad. Now she is in a private hospital.
What are the offences that they did in the FIR?
Malad, the FIR is registered under Malad.
Attempt to murder.
FIR is under 1091 Malad of BNSS. It was Malad, the Ruka was registered, this happened at 9:30 in the night, 9:46 the telephone call was made, Malad, and on that basis, the GD entry was made. The FIR is thereafter registered. At that time, Malad, AIMS, when she was in AIMS, she was not fit to give the statement, but now she is stable and she has been discharged from AIMS and now she is in a private hospital, Malad.
Please find out.
Yes, Malad.
And we will pass an order. Why the hospital denied emergency medical treatment?
Malad, that we will have to find out, Malad.
At your cell number 4,
Yes, yes, your lordship.
there is contradiction. The husband was arrested on so and so. In-laws are absconding.
Yes, your lordship. In-laws are absconding with the,
Madam, read the next line, please.
yes,
Taking 2 minor girl children. You are saying aged 4 year and 1 year.
yes.
Then you are saying eldest girl child.
Yes, there are 3 children, your
There are
lordship.
3.
There are 3, your lordship. And 2, they have taken away. There is no information. And 1, she has been abandoned outside the house of the residence in Gully, your lordship. And then the police came and rescued her, your lordship. And now, your
Where
lordship,
is the girl child now?
now the girl child is at the custody of the mother, the eldest one.
Where are the parents of the
Your lordship, they are absconding, your lordship, and the,
parents of the victim, please?
they are, parents of the victim is with her, your lordship. With the victim, your lordship.
Is the child with them?
Yes, one child is with them, and two of the child, the minor child, Your Lordship, they are with the grandchildren of the husband who are absconding, Your
It's
Lordship.
all right. Grandmother is not something, an alien or, if the
I
child
do
is
not-
1 year old and 4 year old, let them also understand what is their responsibility.
Yes, Your
But
Lordship.
one of the eldest girl child,
Yes,
who is in a very sensitive and impressionable age,
yes.
she is now under the care and custody of her maternal grandparents.
Maternal parents. Yes, Your Lordship, correct, Your Lordship. Only my inhibitions, Your Lordship, is that at night, Your Lordship, they have abandoned outside the child,
Right.
Your Lordship. This is, so mother is very much anxious in the hospital that offer safe custody of two girl minors, Your Lordship. That's all she wanted, the safe custody.
She herself is not in a position to look after, because she now, as a brave woman, she should recover for herself, after suffering these multiple injuries.
Yes.
And that to such grievous injuries.
Yes, Your Lordship.
She must now concentrate first of all her own recovery.
I completely agree, Your Lordship.
Right on.
And Your Lordship, if I may point out, Your Lordship, what I have been told by the victim is that the FIR on
Letter
the,
dated 25th April 2026. Addressed by Ms. Sneha Kalita, learned advocate on record from a Supreme Court of India, was received in the office of the Chief Justice of India yesterday, after the letter sought urgent intervention in the case of brutal assault of a woman advocate named XXX, and grant of compensation to her under NALSA Victim Compensation Scheme. Rather, don't say. In the letter, the learned AOR has sought the following reliefs. Take it from the prayer part 1 to 5. Next paragraph. Along with the letter, some photographs were also attached depicting a brutal attack on brutal assault with a sword, with a sharp-edged weapon on the victim advocate, who apparently has suffered multiple injuries on all vital organs of her body. Seeing the condition of the victim in the photographs, coupled with the fact that she was stated to be under treatment at AIMS Trauma Center, we decided to take suo motu action in the matter. So hence this petition. Next paragraph. With an advance notice, Ms. Aspria Bhatulani, Additional Solicitor of India, is present on behalf of the NCT of Delhi, NCT Government of Delhi. The investigating officer is also present. Next paragraph. We are informed that FIR number. Do we have any number?
Yes, Madam. FIR number 176.
FIR number so has been registered, and the husband of the victim, who is alleged to be the prime accused, has been arrested in the intervening night of 25th and 26th April 2026.
Lordships.
In the complaint, there are allegations against in-laws of the victim, but they are stated to be absconding. Next paragraph. It may be noticed that the victim has three has three daughters born from wedlock, from age 12 years, 4 years, and 1 year.
Deeply.
Learned AR, whom we have requested to assist as a amicus curiae, informs that after the brutal attack on the victim, the in-laws of her in-laws took away two minor girl children, aged 4 years and 1 year, along with them, and their whereabouts are unknown. The eldest girl child, 12 years old, was abandoned at night outside the house by the accused husband, and she was later on recovered by the police. She is fortunately now under the care and custody of her maternal parents.
Grandparents.
Grandparents.
Maternal grandparents, Malas.
Maternal? Yes.
Joint family means her brother, etc. will also.
Yes, Your Lordship.
Parents and the other family,
Yes.
and her mother's family. Next paragraph. Consists of the rights that a suspect stroke accused also possess with reference to the fair investigation, fair and dispassionate investigation, and also to ensure that no one should go scot-free, we as of now deem it appropriate to issue the following directions. And also keeping in view the other mitigating circumstances, we deem it appropriate to issue the following interim directions. 1A. The Commissioner of Police Delhi is directed to hand over the investigation to a fairly senior officer, and preferably a woman officer in the rank of Assistant Stroke Deputy Commissioner of Police. 2I. The police authorities will find out the whereabouts of the two minor girl children and with the assistance of the child counselor will ascertain their The Philippine authorities shall find out the whereabouts of the minor children who are stated to have been taken away by the parents of the victim. If they are being looked after well by their grandmother, comma, the current arrangement can continue till appropriate directions are issued on the next date of hearing.
Financial assistance, Your Lordship.
However, the custody of the eldest daughter shall continue with the maternal parents and their family members as their family members, where the said daughter is presently staying. Next paragraph. We are put up to find out that the victim was we are pursued by the allegation that the victim was initially taken one eye Jagpradesh Hospital and two eye ZTB Hospital, the Kailash Deepak Hospital and 4 RK Hospital, was refused admission by the last 3 hospitals, whereas the first hospital only provided first aid and referred the case to some other hospital. She was finally admitted at AIMS Trauma Center around 6 a.m. We direct the investigating officer to look into this aspect of the matter
Yes.
and submit a report, status report on the next date of hearing. Next paragraph. Keeping on the attending circumstances and the fact that the victim is seemingly in dire need of some financial assistance, especially to undergo treatment and to look after her minor daughters, we direct the Delhi State Legal Service Authority and also we direct the National Authority through its member secretary to release an interim victim compensation interim sum of rupees in favor of the victim. The amount shall be immediately transferred to her bank account by tomorrow. Okay. The next paragraph, the investigator shall submit a further report, status report with respect to the ongoing investigations. Post the matter on so and so date.
Deeply obliged, Your Lordship. I'm really grateful, Your Lordship, of taking up this cause, Your Lordship.
Please look after her, so her life is safe.
Yes, Your Lordship, any date, Your Lordship, will be given by the court master. Your Lordship, there's only one apprehension that the 1 year baby, Your Lordship, she is a feeding baby, Your Lordship. So, Your Lordship, only I'm.
Baby should be always with the mother, but here the mother is not in a condition. That's why we are saying that if she is being looked after well, then allow few days.
Yes, yes.
By that time, she will recover and the child will come to her.
Yes, Your Lordship, deeply obliged, Your
Not
Lordship.
child be given anywhere else.
I'm extremely grateful,
We
Your
are
Lordship.
praying for her early speedy recovery.
Yes, Your Lordship, I'm extremely grateful, Your Lordship, for taking up this cause, Your Lordship.
Thank you very much.
Grateful, Your Lordship.
Lord, in this matter, I am appearing for.
अभी थोड़ा कुछ चाहिए.
So in this matter, in terms of the trial court has fixed the date for May 13th. This is the issue where that witness was unwell. As per their affidavit as well, they are going to make efforts. So if he is well, he'll come hopefully on May 13th. My request, subject to my friend's position, if this could be kept post.
Are left now.
There are many other witnesses now. In so far as this person is concerned, P 272.
Implicate him. One has been.
One has been done.
Yes.
So 272 remains.
Other accused are there?
Sorry, sir?
He is being tried with other accused.
He's been tried with other accused.
What is the status of those accused?
There, some are on bail, most in custody. The witnesses are coming. The trial is proceeding. Trial is not held up because of this accused or this witness. The other witnesses are proceeding. So this witness, in terms of the May,
The trial as it seems to be likely to be concluded against you on 13th May or so.
if not necessarily, if this witness comes, the witnesses against me will be concluded. Then, of course, the FSL, the IO, I mean, that's a separate issue. But there are only 2 witnesses against me. If he comes on May 13th, yes, it will be completed. All that will remain is my phone and some images on it, which I can then argue and leave it to the court. So my request is if it could be kept post vacations, if on May 13th this witness comes, I'll place the affidavit on record and then perhaps we can argue the bill.
No, you are in. Is it a trial? Is it a split trial or it's
It's a composite.
to be now concluded against all?
It's going on against all.
So only 2 witnesses are left.
There are about actually 22 protected witnesses, out of which 16 have been examined. Insofar as this accused is concerned, 272 is the main witness. We want to examine that, examine this 272. Now the summons has been issued. On the earlier occasion, due to his health reason, he could not be examined. Now date is fixed on 13th and 14th of May. I think on that day, his condition now looks better. Once he is examined, I think we can consider after vacation.
This will be the protected witness against you, him.
Main witness against him.
Not protected. He's a public witness. I have no protected witnesses against him. He's protected. So he is 272, his name is known. There were 2 public witnesses whose names are known. One was examined. I placed it on record. 272 remains, health conditions, as my friend said. So perhaps on May 13th, if in fact his condition.
Anyway, whether public or protected,
Yes.
you get them examined on 13 and 14. There are only 2 protected or vital witnesses remain to be examined. The allegations against the petitioner. Both witnesses are scheduled to be have been summoned for 13th and 14th May 2026. Then post this matter on also date. The parties shall extend full cooperation for examination of the above witnesses on the dates fixed.
Thanks.
Yes, item 11.
It's connected matter. I appear on behalf of the state on advance notice, I appear on behalf of the state, on advance notice. Connected matters are coming up on 4th,
5th of May.
5th May, sorry,
Then say issue notice accept notice on behalf of the state of Chhattisgarh, counter affidavit can be filed.
Yes, on the, before that,
What is the date?
5th of May. 5th of May, next week,
Before the date fixed, list on 5th May 2026 along with SLP criminal number 4299 of 2026.
Grateful.
But after 12, the main matter is not yet been listed, my lord. That is 18422, my lord, because on that day the list was already allowed. So there, my lord. 18422. Yes, my lord.
That connected matter.
18422 of 2026, that is the diary number one. 2 matters are listed, the third main matter is not listed. That number.
On that day you said tag with this matter.
Yes, ma'am, that's right, but on that day, because the list was already published, madam, therefore, this matter is not listed, madam. 18422 madam. This is the main matter, madam. 18422 this is the main matter, reversing matter.
15565 is the main matter now.
Yes, madam, main matter.
Is it listed today?
The main matter is not listed today, madam.
15565 listed
It is not the
today.
main matter, it is relied upon reversing matter. Both the matters are relied upon reversing is the main matter. So it may be listed after a week, madam, with reversing matter. I am giving the diagram. In other 2 matters, madam, the no notice was issued.
Mr. Stiga, on 24th April you said
On
tag
that
this
day, madam,
matter with SLP 15565.
that is the second matter. As far as the first matter is concerned, that is not listed matter.
You give us the first also. What
Yes,
is
madam,
it?
18422 2026.
So इकट्ठा पैक कर दूं.
Oblige, madam. 18422.
Item 14, Lord, couple of issues, 13, Lord, couple of issues arise. Lord, the petitioner society is not a party to the agreement. The trust who invokes the arbitration is a complete third party, not even having any agreement either with the flat purchasers or with the society. Lord, second important point is, Lord, we have filed a suit, and in that suit, Section 8 order is passed against us. A writ petition is pending. Now, when there is a writ petition pending invoking Section 11 and passing order in 11 in detail, makes my Section 8 order infructuous, my lord. Lord, my whole entire petition becomes infructuous in that case.
These questions will
No, my lord, Section 8 order, my lord, if my lord turns to page, my lord, Section 8 order is against me, against which a writ petition is pending. My lord, now Section 11 passes the order. Because of the Section 8 petition, the order passed in Section 8. Now my writ petition becomes infructuous in the process because one bench of the High Court will not entertain the petition which is already in challenge, Lord. And whole Section 11 is a consequence of Section 8 order. Lord, therefore the situation is,
I find no basis to deny allowing this and making a reference to this. Of course, leaving it is appointed to it.
a Section 8 becomes, the challenge to the Section 8 order becomes infructuous by this order. Nothing remains in that application thereafter, my lord, because on the judicial side, if Section 11 is decided in this manner, what is going to be decided in the pending writ petition? The entire petition becomes infructuous.
Been pursuing the Article 227 application.
No, that's not, my lord, matter is kept on 4th of May. Court said we will take it finally. Therefore, since the court said they will take it finally, we have to go by what court suggests, my lord. We can't push the matter for the.
When the Section 8 order was passed.
My lord may make it time out any time. It's kept on 4th of May. I have no issues on that. My lord, what happens is today my entire petition becomes not infructuous, my lord. Section 11 deciding the issue only because Section 8 order is passed against.
Someone's disposed of in November 23.
But we have,
November 23 and in 26, Section 11 application being allowed, keeping the issue of maintainability and jurisdiction of the society.
we decide by the
open,
arbitrator.
open with the arbitrator.
No, but
When is the-
I'm on this Section 11 order. Please bear with me, my lord. This Section 11 order
is a consequence, if you see the order application, is a consequence of order passed under Section 8 against me. My lord, that Section 8 is in challenge. My lord, I have no difficulty. My lord may fix it on any date. We will go and argue that matter. My lord may tag both the matters. We have no difficulty. My lord, but today, not examining the suit, not examining the details why the arbitration is not required to be done. If all this is adjudicated in 11, without even considering what my prayers in the suit are, where third parties are there in the suit or not, my lord, what happens is what will remain in that challenge to Section 8 order, my lord. But otherwise, the court will say it's already order under judicial under 11. Other bench will be bound by that order. My lord will tag both the matters together. I have no issues. Any date which my lord fixes, no issues. My lord will go and argue the matter tomorrow. If my lord says tomorrow, it should be argued. But in this manner, making by writ petition infructuous makes no sense. My lord, secondly, my lord, another SLP is pending in respect of the same property. Office report, if my lord sees, in respect of the said property. Please, my lord.
Shivaranjan case.
No.
Shivaranjan Towers.
Same party, same property. Same party, same property. Office report says that another petition is filed by a developer here, and that is notice issued and pending here. That is against the deemed conveyance granted in my favor against the same property. Lord, therefore, whole issue is because of the property.
That is the competent authority.
That is challenged.
The order against the developer for handing over.
That's correct. So therefore, but
That's a different.
let him do
Here the dispute is.
my main dispute. My dispute is
whether the part of the property which you say you have a title can be bequeathed to the religious trust. That is the issue.
Therefore, if a deemed conveyance is passed in my favor, that is in question here. To what extent my petition will survive if I succeed in this matter is another question, my lord. My only request is at this stage, my lord, I have nothing else to add except saying that Section 8 has to be decided on merits. My lord may fix both the matters together anytime. I have no difficulty about that. But in this indirect way, it becomes infructuous.
Of the scope enlarged in para 40, arbitrator can go into all the questions.
The issue is kept open for the arbitrator and for you again to agitate it before the arbitrator.
So then you have to go to the arbitrator. But what happens is to my suit, which was much wider. What happens to my suit, which was much wider, if Section 8 order is passed in my favor, then his whole entire exercise is irrelevant, my lord. My lord, order under 11 is passed only as a consequence of order passed under Section 8. Lord, our contention is there is a BMC party in that suit, there is a government party in that suit. The questions are wider raised in the suit.
It is sought against them, they are proper parties. BMC and the government are only proper parties because the government is the competent authority for the purpose of executing the deed.
Sanctioning the plan, no. Government is not proper, sanctioning the plan. Lord, plans are proposed by them. So the whole question is
proper parties.
No, therefore
claimed.
In arbitration they are not parties. They have not made.
Need to be parties.
That's the whole point. Therefore, is my suit argument.
Real crux of the problem is what you are pointing out, that the juristic character of the society is independent of its individual members. That is the only argument that you are advancing to come out of the arbitration clause. And the single judges said that this is something which a prima facie hold in terms of Cox and Kings, that there is a commonality of interest. And therefore, let it be sent to the arbitrator. Arbitrator will finally.
I quite see that. My second submission, which is discussed by the High Court in para 47, when we point out that this is Section 8 order, which is passed by the civil court, and the writ petition is pending against that order, and 11 is only a consequence of that order. Now, Lord, therefore, you have to wait for 8 to be decided. Finally, or you club it together, I have no issues about that. What happens is without examining the plaint. Now, plaint is not before a court under Section 11. Without examining the plaint, to opine to this extent, literally non-suits me in my pending writ petition. Lord, nothing remains thereafter, my lord. Lord, therefore the submission is, my lord, we place both the matters together and we will argue at any time, any date. We will not seek any adjournment, nor that we have sought earlier, but we will not seek any adjournment. No difficulty about that also, my lord.
Thank you, Mr. Joshi. Okay.
Lord, may I then make one request? At least to the extent that unaffected by the order passed under 11, my writ petition will be decided. Otherwise, we are making my writ petition infructuous. That literally amounts to making my writ petition infructuous.
In view of the scope of, in view of the enlarged scope of the arbitration proceeding, as discernible from para 40 of the impugned judgment, we see no ground to interfere with the impugned judgment of the 10th February 2026 of the High Court. As regard to the pending resolution, the petitioner shall be at liberty to request the High Court for out of turn hearing. That such an application be considered sympathetic.
May it please, Lordship. Lord, if your Lordships will have the minutes of the Vigilance Committee's meeting, my Lord, at page 186, my Lord. The Vigilance Committee, my Lord, today concludes. I'll do this. My Lord, in fact, your Lordship.
Question notice, Universe 1 then accept in behalf of responder 1. Meanwhile, operation of the interim government shall remain state. If Malina counter affidavit within within 4 weeks.
Great.
Please matter if within 2 weeks thereafter, post the matter on 7 today. Meanwhile, operation of the interim government shall.
Lord, can I make one request? Lord, can I make one request? Lord, the proceedings, Lord, is all complete. Everything is complete.
If the disciplinary proceeding comes to an end, sir,
3rd of February, it has
it comes in your favor, everything is.
I bow down. That's what I was making a request. Lord, 3rd February, it has been, everything is closed. Let that be decided.
Meanwhile, applied Janki Raman ratio very literally, but substantively it should be kept on hold till the discipline.
I bow down to that.
Meanwhile, as suggested, as requested on both, from both sides, the High Court may continue with the dispute proceeding and make an endeavor to conclude the same at the earliest.
Obliged. Deeply obliged. Lord, I appear only for one, my Lord. There are other respondents. I only appear for one, my Lord. Obliged.
No, in 15.
My Lord,
He is mentioning the previous matter. My Lord.
Only for one of the rest.
Lord, I appear only for respondent number 1, 2 and 3 are also there. NCT, etc.
But only for number 1.
Yes, Lord, I only for one.
Judicial office.
Yes, I'm only for. Obliged.
Wait. My Lord, in item 15, my Lord, this honorable court has already reserved judgment. And this honorable court has already reserved judgment, my Lord, but after the judgment, many orders were being passed, so similar orders have been passed, my Lord, from time to time. In the additional volume, my Lord, in extra 9, if your Lordship will just see, page 85. Paragraph 5 and 6 of this order. Kindly have.
This bench also passed similar.
Yes.
No, this is so just a particular. That's additional papers you have.
Lordship, please. Annexure 9, page 85.
Then to await the decision in SLP serial number 19366-19369/2023. Meanwhile,
Paragraph
further
5 and 6.
proceedings pursuant to the improved show cause notice shall remain state.
My Lord, we've crossed the stage of show cause. It's passed an order. So para 6, my Lord. Page 164 is my prayer. Page 164 is my prayer. Lordship. Obliged.
The Lordship, in item 16, my Lordship already been asked to issue notice in the lead matter.
Also tagged with a civil number 6175/2020.
Matter is coming up on 8th of May.
There are three subventions.
Delay, there's a delay, it may be continued.
19 and 23.
Item number 7.
Why are you coming of 2019 orders now?
Lord, because then after COVID started, Lord, and I was not aware
No,
of
no,
this procedure.
2019 orders of DRT, you don't challenge anywhere.
Lord, because the same question of law, because I booked the flat in Lord.
No, 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 this fraud has to be now.
Just allow me to show me Lord, two documents, my Lord. My Lord, in 2013, I booked the flat. Loan agreement was signed on 2013, my Lord. Just page number 73, my Lords.
So these paper books be, soft copy of paper books be handed over to Sri Rajiv Jain and the Michael Spear in the lead case. What's the matter for further review and so on?
Let me just request no pursuance, because they have issued a show cause arrest, my Lord, or warrant, my Lord. So
No
that is,
stay, no question of stay unless we
I'm not asking only stay on the proceedings, my Lord. The proceedings may continue, but
hand over to Mr. Rajiv, then we'll see.
Lord, just stay from the for arrest warrant, my Lord, because they issued the arrest warrant.
Item 18.
Your Lordship, in this petition, the question that has been put forth was not answered by the Honorable High Court. It requires interpretation of Section 169 of the Representation of People Act. I have two broad submissions, Your Lordship. Number one being that under the Symbols Order 1968 that was passed by the formulated by the Election Commission of India, the order number 6B and 6C, it provides how a political party can be a state party or a national party, and that would be a recognized political party. Now, it lays down certain criteria for it to be a recognized political party, which is that it requires a minimum number of votes. For a political party to have a minimum number of votes, it needs to have some sort of visibility, Your Lordships. But
You have to go to people, create some vote for yourself. Absolutely.
Apologies, Your Lordship.
Go to masses, create some vote bank for yourself.
Absolutely. But Lordship, the Representation of People Act, there are several provisions like 38, 39, 77 that provide that the visibility will be given only to recognized political parties. It provides that
That's a reasonable classification.
that is justified. However, Your Lordship, under 169, this reasonable classification needs to be made by the central government. Section 169 says the central government under the Act is empowered to make rules with consultation of ECI. And this political party word was coined in 1989. An amendment was made in the Act. Therefore, this governance of political party has to be made only under this Act under 169, Your Lordship. ECI had power until 1989 through Article 324. However, post that, this power is now given to central government to formulate these rules with the consultation of ECI, which has not happened. If Your Lordship may just have 169 of RPA.
Yes.
It says the central government may, after consulting the Election Commission by notification in the official gazette,
With your political party, what kind of symbol are you interested?
It's not merely about the symbols, Your Lordship. It's about visibility. It's about visibility to the masses, for the masses to be able to vote for new ideas. If we are only recognizing few political parties, then the newborn political parties can't even propagate their own ideas, and we as electors don't have any options. We don't even know about their existence. There is a certain limit given on television broadcasting that is not given to the parties that are not recognized. They are not given benefits that recognized political parties are given. It's not about classification or discrimination, Your Lordship. It is about the rules that are to be framed under 169. It is solely to be done by the central government. It was valid till 1968. However, after that, once the 1989 amendment came and added the term political party in the definition clause 2F and for the registration of political parties in the 29A, section 29A of RP Act, then it became the power of central government to make those rules under 169 with consultation of ECR. That's my submission, Your Lordship. It clearly says
We
election.
appreciate you are very well prepared. Keep it up. We really encourage you. But argue some good case.
Your Lordship may just consider that this is a very good case. It gives the new young born parties a possibility to be visible to masses and us as electors to vote for new ideas. We are just constrained to the recognized ones.
Thank you, young man. Thank you, young person. Lady, very good, well argued, and very well prepared. Come in some good case. We will really appreciate.
Thank you. Grateful, Your Lordship.
Item 20 covered. Covered 20 earlier.
Item 20, my lord, similar matter has been dismissed. Leave the question of law open as the order is there.
Next matter is admissible.
Yes, item 21 and 22.
Yes,
GC.
well, I just a convenient chart for both 21, 22. We have the same prayer in both. Your Lordship gave us liberty to file writ petition. That's why we're here. This 20, 21, 22 are identical. It's only about the direction for DC link. That's all we're asking for. Because regularization had to be done. That's been done. The
Now, anyway-
payments, I'm sorry.
Copy. No copy of this note, yeah.
These payments which we had to make, Manoj,
No,
conversion.
why are they coming directly to Supreme Court?
Your Lordships, on 11th March 26, when you disposed of those old 1985 writ petitions, the Lordship had said that liberty is given to us to come directly by way. That's why we're here, my Lords.
So,
Paragraph of,
in fact, you don't require even liberty because in terms of that order, now you are entitled to go to High Court.
no, I'm just reading that one paragraph, my Lords.
Orders for
If due to such previous directions, leave of this court is required by a party, such party shall be at liberty to approach this court through a fresh writ petition, giving all necessary particulars.
No one, which is the order which says 14th Supreme Court order?
9th September is the one which talks about DC this month.
Yeah.
Where it says DC link, regulation only, regulation concerned by that, that's it. That will be 24. 23rd February order.
Nine something for which year? You never mention years. There's some reason.
So this says that unless there is regularization, including can be maintained. We have said regularization happened, we are bound by this order. Therefore, then that.
The petitioner has got an independent cause of action, a fresh and independent cause of action, for which he is entitled to invoke the writ jurisdiction of the High Court. And if he does so, it is clarified that the impediment mentioned in para 7 of the above mentioned order, that para 7 of the above mentioned order shall not cause any impediment.
The only thing is, my Lords, that order of yours says that if we are coming against the order of the Judicial Committee or the Monitoring Committee, we go to the High Court. We are not coming against those orders. The previous page of that MC Mehta order, your Lordships have said that appeals challenges to orders of the Monitoring Committee and Judicial Committee shall stand transferred to the High Court. We are not coming against that. We're just asking for our decision because we made all payments. The problem is MCD has filed one application last year. That application is asking for a general stay in the against Judicial Committee's order, and that is pending. They haven't even pressed it, moved it. So everybody who makes the payments gets a regularization. All these shops will constantly keep filing petition. I'm sorry.
You start the beginning, once you will go to High Court, at least you will be able to send all those MCD matters also.
Very well, very well. Your Lordship, thank you.
And again, para 7 will not be an impediment.
Can I beg for expeditious disposal?
With above mentioned liberty.
Because we made the payments in 2018, can I beg for expeditious disposal? Because 2018, I've been waiting. It's just, these are all restaurants which are running in the defense colony market. Manoj. So we just want now the access because it's permitted now for me to use it. I can't use my own premises because of this. The above floors I can't use. Second and third floor, I don't have this permission. It's been 8 years now. First and second.
What else we can mention in the order?
Expeditiously, once the High Court petition is.
We request the High Court to provide expeditious hearing to the petition.
I'm grateful.
I don't face the success.
No, that's subvention matter.
Disposed of infringement.
This is appeal tribunal.
Lordship, 25 is,
Criminal.
because the appeal is pending, Lordship, it may be disposed of this expeditiously because 29th is the election.
No, have you approached the appellate tribunal?
What is the expedition now? There is no expedition.
In fact, I am the passport,
Tomorrow is the-
I am the passport holder day after.
Tomorrow you say that your right will be restored.
Lordship, in
if you
terms of the earlier.
In any case, you will be entitled to. In view of the fact that the petitioner has already approved the appellate tribunal, from the instant the petition disposed of, with the liberty to the petition to pursue that appeal.
No, sir. Oblige.
Please, but this is the interpretation of a regulation which will impact all the banks, your lordships. Under the Pension Regulation Act. State here.
Of his pension.
Your lordships,
We
not the
understand
issue.
your argument.
Yes, your lordships,
You
that's
have a
not
question
the
of
issue.
law which needs to be addressed. But
Yes, your lordships.
on point, on
Because
equitable point.
SK Cool has created a problem. If your lordships will just take page 31, this class is absolutely excluded by the regulation.
We
And-
understand you on the point of law.
Yes, your lordships. And this point of law is very important.
The pension given to some.
Lordships, this is what is going to impact all the PSU banks.
That question of
this-
law can be kept. open.
Yes, your lordships, this question of law has to be examined by your lordships because lordships will give me the indulgence.
We also agree with you
Yes, your lordships.
to hold that the regulation 22 will govern all employees and not only workmen.
Yes,
It
sir.
will be contentious.
Your
Then
lordships.
These particular employees governed by the 76 regulations.
May I suggest a way out, your lordships? The way out, your lordships, is that the question will be considered by your lordships because the problem is created by the SK Cool judgment, which is a Supreme Court judgment.
But SK Cole was not an.
Judgment on officers. It was a judgment on workmen.
That
And
is what we are saying.
yes,
SK Cole has been incorrectly understood by
yes,
the High
that is
Court.
that is the main thing, your
What the
lordships.
High
And this
Court
is,
says is that the Supreme
But
Court
you're
has
not confined
applied
to
here,
workmen.
not confined it to workmen. That is wrong.
yes, your
The
lordships.
regulations are independent. A
I'm
bilateral
most
settlement between an employer and a workman cannot govern the employment contract of non-workmen.
I'm most grateful, your lordships. And the
That is the
statute
question of
also.
law, definitely, but the.
Yes, your lordships.
After all, in the
That's why may I
employee-
suggest a way out, your lordships? We will pay him subject to the outcome of the petition. Let us, because this question has to be looked at, because your lordships, now there is a whole lot of other petitions for my bank, and I'm told even other PSU banks, your lordships. And the banks, all the banks under the All India Banks Federation have brought about an amendment also.
He's not been paid for 18 years, your lordships.
Because there is a forfeiture of service. So
We need to examine this
Please,
issue,
your lordships.
but we don't want to do it at the cost of your client's well-being.
that's the reason why I'm saying your lordships may ask, may allow me to pay him
and subject to the outcome of this petition, Your Lordships.
What were the charges against you?
Please, Your Lordships.
Loan advancement. Clerk, he is a clerk.
No, he wasn't a clerk. He had become a senior manager. He had started as a clerk, then he became a senior manager. And the
Scale 1.
Yes, Your Lordships. And the fraud that he was committing, that he was sanctioning loans, Your Lordships, without the requisite
Verification of record.
qualifications. And Your Lordships knows one person on the desk brought down the whole PNB bank, Your Lordships. That one person who negotiated all those LCs, Your Lordships, the whole bank came down because of that. This is a very serious issue for us, Your Lordships. And this is not just one instance. There are several instances where he is consistently sanctioned loans without requisite verification.
Lordship, let him be paid subject. I agree with my learned senior. Let him be paid subject to outcome of the petition.
We are already paid.
Foreign workman, that is the point.
No way.
One, issue notice. Then say, Madam, accept notice on behalf of the respondent, counter affidavit if any filed within 4 weeks. Please wonder if any within 2 weeks thereafter. Post the matter on so date. While pension be released to the respondent.
Lordships, the other thing is we are releasing his statutory dues, which are gratuity and pension, gratuity and PF, Your Lordships.
Yes.
That should be sufficient, except for pension, all dues.
Gratuity and PF.
Yes, Your Lordships, we are
You get the gratuity.
releasing that.
Meanwhile, the gratuity and provident fund
Be released.
All statutory dues, Lordships can say, except for pension. Because unfortunately, my zonal manager was hauled up in contempt also, Your Lordships. That's the difficulty. Very grateful, Your Lordships.
It's 27, my apologies, I'm seeking a passover, I'm being led by Mr. Giri. It's 27, I'm seeking a passover, I'm being led by Mr. Giri, he's on his legs. Let's, 27, I'm seeking a passover.
ये पहले वाला बैंक का मैटर भी क्यों लगा रखे हैं? So unnecessary.
I appreciate, but something may have to be done about the order. I'm just seeking a
Order is,
passover.
or, let us say the order is academic. Let the authority say that.
You can communicate.
The authority,
your presentation is already
the
decided.
authority has in fact, if my lord sees, my lords may just pass it
The
over. Mr. Giri
authority has
here.
decided the representation which he claimed to be pending.
Certainly.
Right? According to you, it's an incorrect statement.
Who is
Certainly.
to argue the case?
Mr. Giri.
Huh?
Giri.
Mr. Giri is leading me. My lords may just pass it over. I can
This is
certainly.
also presence marker.
I quite see what has fallen from my lords, and this is something I see that maybe a contempt may be an issue, but something may have to be done because of the consequences that have ensued after my lord's order. That order is not interpreted.
Contempt conscious.
Please,
then
my lord.
almost every alternate petition contains false
I
statement.
completely understand. My lords may just grant a passover. Something may have to be done, although about the order, because my lord's orders carry a certain weight.
Say we have heard Shri Vigri learned senior counsel for the petitioner. Should we say in absentia or in person?
My lords may at least pass it over. Otherwise, I can show a subsequent event that has happened.
Same time.
They are not inclined.
My lords may in that event at least see one order that is passed. My lords will understand that contempt may not.
We are attributing Krishna-like qualities to Mr. Giri.
No, my lords,
He's
that's
omnipresent.
my lords, please, there is an additional documents application that I have filed. In that event, my lords may hear me for a minute. My lords will understand why we have approached my lords.
No, Mr. Giri.
Mr. Giri is here.
My lords,
Mr. Giri, we were attributing Lord Krishna's qualities in you by making you omnipresent everywhere.
for a contempt. They'll have to be told that something may have to be done because of this order, because of 15(4).
Had this been brought to your lordship's notice, at that point of time, your lordships would not have issued a direction to dispose it off.
But not confirmed.
No, but this order then, when will have to be dealt with. This subsequent order that is passed in terms of this order.
So we have heard Sri Vigri
No, Milord, your lordships.
at a considerable length. We are not inclined to, in the facts of circumstances discussed, we are not inclined to initiate contempt proceeding in this.
You'll have to do something about the order. This order, there is a direction.
Lord, I thought if your lordships had a look at, if your lordships had seen page 13, there is a direction to dispose it of. And at that point of time, there was already, my lord, that had been
He's already disposed of, compliance report had been filed, we've seen it. He appeared in person, Mr. Giri, and
That's correct. But it was his wife, my lord, who was one of the petitioners, my lord, before the High Court.
so let the authority say that the issue has already.
Two-line order only.
No, my lord, then if your lordships could kindly say that, my lord, not in contempt maybe, but let the authority say that it had already been disposed of.
The authority take a call.
We can't, see, this is what they've done.
No, my lord, please have a look at, my lord, please have a look at page 12
Of additional documents.
of the additional documents. Please have a look at page 12.
Quite see that this is not a contempt. This is my problem. This is how they're
Yes,
interpreting your order.
They interpret the order passed by your lordships in this way that it has to be done again. If they are given the liberty, my lord, to take note of the fact that there was already an order passed pursuant to the direction of the High Court, my lord, that would suffice.
Then nothing, those two line they can communicate that you are unnecessarily abusing process of law. We have already rejected the.
My lord, can I pray for this, my lord? Can I pray for this, my lord? Can I bring it to the notice of the authority concerned? If maybe not in contempt, but at least, my lord, pursuant to the fact that,
Definitely.
then, my lord, I'll withdraw the contempt, but with the liberty to take appropriate action before the authority, including the fact that an order was already passed. No, but that's okay, my lord. I'm not saying that your lordship should mention that in the order. I'm saying that could your lordship say, I'll withdraw the contempt, I'll withdraw this, with liberty to take appropriate action before the authority. That's all what I want.
State our construction in terms of.
You'll have to do that.
It is not such a serious issue that.
Representation, that's it.
State.
Take action. We'll have to take action.
Good. Also, the counsel for the petition section. We want to withdraw or we simply say we are contempt is between us and them.
No, my lord, your lordship should say that it is disposed of.
That he can.
With liberty to me to take.
Before the authority at the time of consideration of.
Correct.
I'm noting down now.
The sugar counsel for the petition permit that it does not press this contempt petition as the issues, they can raise the concern before the prescribed authority. As they would raise the concern before the prescribed authority. With liberty aforementioned, the contempt petition is dismissed as advanced.
Okay.
Next item 28.
Lord Krishna was much more successful.
Malad's connected petition, Malad, is coming before my lords on Thursday, April 30. This will be taken on Thursday, Malad.
Pending before the High Court of Sikkim.
I'm sorry, Malad.
Similar issue.
Yes.
Pending before the High Court of.
No, Malad, that's some other employee. Malad,
Correct. On
Yes.
the same premise that did not have requisite qualifications.
no, she is actually.
Whether could have been given the.
Malad, she is not in my cadre, so nothing to do with my cadre or the cadre coming on Thursday.
Question, Mr. the question.
Yes.
Question whether a person is not competent by way of qualification.
Yes.
Then the situation can be addressed by referring to the relaxation powers of the Hon'ble. That is the basis.
Malad, the companion petition is coming on Thursday. Can I address this question on Thursday before my lords, Malad? My lords permit me. They were filed on the same day, but they've been listed on different days. So my lords may have them together on Thursday, April 30. Malad. Malad, it's coming before my lords on Thursday, Malad. The issue here, Malad, is that Malad, there is a show cause notice, but Malad, the promotion which was done in 23 and 25 on orders of the Chief Justice, Malad, whether it can be revoked without any complaint, so motu, etc. Malad, I don't want to address today. Can I address this on Thursday, Malad, with the other petition?
Chief Justice find that there is some undue favor done.
No favor, Malad. It's under the rules. There's no favor and nobody else is prejudiced because there was only one person in the feeder post. There was only one person in the feeder post, no one else.
He did not have the requisite experience.
Yes.
Now, you are pointing out to a rule where the relaxation may be
Well,
given.
it's under, because there was no one else in the feeder post and the post would otherwise have been vacant. Well, I'll show on Thursday that it's in accordance with the rules, Mullahs. I'll show on Thursday it's in accordance with the rules. I've placed the rules, Mullahs. Nothing contrary to the rules. Mullahs may just have it on Thursday.
On Thursday, what will happen?
Well, Thursday, the other petition is there, Mullahs, by other employees. I've just handed across, Mullahs.
No, we are only on the other point that why should we entertain a petition against a show cause notice?
Mullahs, can I address that on Thursday, Mullahs? I can do it now or on Thursday together because the same issue will arise there.
Whatever you want to argue before us,
Yes.
you argue it in reply to a show cause notice.
Yes.
Take all the plea. If the order is passed, adverse order passed, you challenge that order before.
Mullahs, the reason is that, Mullahs, we are saying two things. We're saying that one is, Mullahs, no, we are questioning the power, Mullahs, to revoke a promotion.
Petition against a show cause notice, Mr. Sibal,
Mullahs,
is well known.
Mullahs, I don't want to say it, Mullahs, today, but Mullahs, whether there is power to revoke a promotion made several years ago, so motu without a complaint is an issue of jurisdiction of show cause
Plea
notice.
you raise before the High Court. High Court, let the High Court consider an administrative side.
So, Mullahs, the problem is, Mullahs, that the full court has passed this order and we are questioning the power to pass such an order.
Every day judges set aside the full court decisions.
Yes.
At least in my lifetime in the High Court, I must request 10 to 12 full court decisions. And
understand.
most of the decision to which I was myself was party.
I appreciate, Mullahs, that's a very
That is
large
not-
court. This is a just
Judicial
three
power
learned
and
judges,
judicial
Mullahs.
power is something different.
Well, this is Sikkim High Court. There's just three learned judges. It will go before one of them. My lords, have held in Al Qureshi that, my lords, if on the administrative side, the High Court takes a decision that none of the judges party to that decision should hear, my lords, a petition against that. That's Al Qureshi. My lords, I'll canvass this on Thursday, my lords. So I said Vico. Vico.
The petitioner has.
Mullahs, may have this on Thursday, Mullahs. The other petition is coming. I don't want to prejudge that petition today, Mullahs. That's
That you stop that other petition also, we are.
Mullahs may hear both together, Mullahs. They were filed together. It comes from the same meeting.
The petitioner has approached this court under Article 32 of the Constitution
Mullahs, can I just say the others are termination notices, Mullahs.
against a show cause notice, seeking his response with respect to the eligibility conditions, with respect to fulfilling of the eligibility conditions.
At least if you go with liberty, let him not take a view.
When he was promoted as joint registrar in bracket IT and as additional registrar in bracket IT. It is true that the show cause notice has been issued pursuant to a resolution passed by the report of the High Court. However, nothing precludes the petitioner to submit a comprehensive reply based upon all the contentions which he has raised in the instant writ petition.
Mullahs, can I indicate something that I haven't brought to my lord's attention after my lord's finish?
No reason to
Keep a
doubt
copy
that.
of this. Keep a copy of this. Give a copy.
We have no reason to doubt that the High Court will consider such explanation cum representation
This.
objectively.
And give-
Objectively. Mr. Sibal, now listen, last
Yes,
class.
I am.
However, in case an adverse order is passed against the petitioner, High Court is requested not to give effect to such order for a period of 2 weeks to enable the petitioner to avail his remedy in accordance with law.
Very well.
That takes care of your
I'm obliged.
problem.
I'm obliged. I just want to bring to my lord's attention in the other matters.
We will,
I'm grateful, Mullahs. I'm grateful.
because against a show cause notice, we will lead to a very dicey law laying down that even against a show cause notice it is maintainable.
I'll tell my lord, it's somewhat interesting, Mullahs. In the other matter which is coming on Thursday, my lord has passed the order, Mullahs, and I'm grateful. In the other matter on Thursday, when a reply was filed, Mullahs, the response from the administrative side was that we have taken a decision on 2nd April that her services be terminated immediately after serving her a notice.
If that matter has been filed and it is cured, defects are cured,
Yes, Mullahs.
then we can
Yes.
Here also show cause notice.
Show cause notice where bullet she said, look, I am filing a Article 32 petition. They responded saying, look, in any case in that meeting, we have already decided to terminate you. That's the order. I've got a document to that effect saying they've already decided to terminate all those people. Bullet. That's the difficulty. Just give that. Just see that. That's the problem, Mullets. And we apprehend that even in this case, today's case, such an order has been passed internally, though we don't have a copy, Mullets. That's why I wanted them together, Mullets. Just to show that, Mullets, where a show cause notice is done with a predetermined conclusion or without jurisdiction, my lords do interfere at show cause notice stage. Just kindly see the quoted paragraph, Mullets, page 1. Just have page 1, Mullets. Employees terminated, Mullets.
That PO.
Yes. No, and others, not just peer. 6 in total, Mullets, different employees, though appointed in accordance with the rules I'll show. And the document I've just handed up says.
Where is the show cause notice issued to them?
Yes, it's in that petition, Mullets, which is not listed today. It is listed on, it will come on Thursday, Mullets, before my lords. But Mullets, this document shows last 4 lines that Mullets, they have already decided to terminate. So it will be an exercise in futility. Since her appointment, I'm reading the last 4 lines at page 1. This is from Mullets, the administrative side, to the person concerned. Since her appointment was in contravention to the relevant rules, no complaint, this is all suo motu, her services be terminated immediately after serving her a notice of 7 days. It's already a predetermined conclusion, unfortunately.
Any?
6. 6 separate ones. 6 separate show cause notices.
On the oral mentioning, a repetition so and so is taken on board. Then is held mention of counsel for the petitioners. Since the petitioners have only been served with the show cause notices as to why their services be not terminated, comma, to grant liberty to them to submit their representation cum explanation before the High Court.
Extension of time.
Let such explanation be objectively considered by the full court of the High Court. However, if adverse orders like termination of services are passed against the petitioners, such orders shall not be given effect for a period of 2 weeks to enable the petitioners meanwhile to avail their remedy in accordance with the law.
You want extension of time to reply to this proposal? Yes. Would my lords kindly afford us further week to respond to the show cause notices because the time has expired.
2 weeks from the date of the order.
No, I'm saying, Mulad, just to respond to the show cause notices, could we have another week, Mulad?
The petitions.
Because we've asked for the materials, they haven't supplied us.
Time to submit their reply come show cause.
And if they can provide the materials underlying the show cause notice, we have asked for it, none have been provided, Mulad.
Your reply, you know the material very well, what is there.
I'm sorry, Mulad.
Your material questions of compliance with rules.
No, for example, Mulad, the minutes of meeting of the administrative side, which Mulad.
Page 1, Mr. Sipak, page 1.
Yes.
The appointment is said to be rehearse an advertisement,
Yes.
rehearse the relevant rules.
My lord.
So if that is so, it's a question of law. You
Yes.
have to just show that yes, this was in compliance with rules, and even if so,
Other five.
there was a provision to
Was in the
relax those rules.
was in the other 5 cases, the creation of the post itself is questionable. No fault of the employee. They were validly appointed, not their fault. No one has complained.
Definitely.
Creation of the post is questioned.
In such situation, the employee is a crossfire victim. If there is no post and we appoint,
No,
the
it was
administration
created-
appoints 10 people, who is going to bear the establishment expenses? On which establishment the charges will be?
Mullah's Chief Justice created the post under the rules, and now Mullah's after years it's questioned.
Cannot create a post, rehearse the concurrence of the state government.
Mullah's state government delegated Mullah's.
Can-
State government delegated the power under Mullah's Article
That-
229.
You've got your answer,
That's in the other petition, Mullah's. We've annexed that here as well, Mullah's. It's there in this petition. 172, Mullah's.
You see 229 powers, this is plenary of the Chief Justice, apart from questions where it has an impact on the expenses. Where the consultation with the government is necessary.
So, Mullah, that delegation was done, Mullah. So, when he exercises that power, he exercises it as the governor because he's a delegate of the governor.
Exactly where a very strong question of a lawful delegation comes in. When the constitution allows a consultation between two independent entities, one heading the judiciary and one heading the executive,
Yes.
can the executive, just see the vice versa.
Yes.
If the Chief Justice was directed to delegate powers to the state government, it would be completely in violation of the basic principle of independence of judiciary. And what you do here, you create a potentate. When the executive power comes into the judicial hands and appointments are being made.
But this was a delegation by the governor, Mullah.
That's what we are saying.
This is what is there at
These are
Annexure
principles,
P11, Mullah.
But it's not-
I would submit it would protect the independence of the judiciary, that they don't need prior approval of the Mullah's executive to Mullah's create a, which is unquestioned till now and no complaint against it.
We'll examine this aspect and let.
And the unfortunate thing in what I handed up, Mullah's, is they say we have already decided to terminate
Full court.
after, we have decided to terminate after 7 days notice. So then, Mullah's, the show cause notice becomes an empty formality, Mullah's. Mullah's,
We'll examine this aspect when the matter.
and we'll have to approach my lords because, Mullah's, it's only 3, Mullah's, only 3 learned judges on the administrative side. Then approaching one of them, Mullah's, hold in Al Qureshi, that Mullah's, no learned judge who was party to the order on the administrative side can hear a challenge on the judicial side.
Anyway, we might send you to a neighboring high court. You never know.
Certainly, Mullah's, always do that. But my lords have been kind enough to protect us in the meantime, and we are
We
grateful.
have done, we have done.
All right. Obliged, Mullah's.
Item 29. This wala matter is not paper. Give advance copy to them. Item 30.
My lord, this is the
30.
item 30. Dr. Pujari is appearing online. She may be unmuted.
Yes, item 30.
My lord, in item 30, Dr. Pujari is appearing online. Dr.
Please-
Anandita Pujari is appearing online.
Unmuted now. I'm grateful. My lords, in this matter, a very serious issue of child trafficking has been raised, my lord. And although a lot of work has actually gone into it by now and portals have been created, however, by this petition, we are praying for sampling, DNA sampling to be done and other mechanism to be created, which has been indicated. Please, my lords.
The issue is definitely very sensitive issue, and we appreciate that you have taken up this cause. But do little more, ask your juniors also to do little homework. Give us a framework that what should be the solution. Problem we have understood.
Yes, my lords.
Now, instead of looking to the government machinery or here and there for the solutions, we would like to that you please suggest what is the solution.
Please, my lords.
We can take a bit up to 2 weeks, 3 weeks, 4 weeks, but meanwhile just ask them to apply their mind, think of what can be the, how the different kind of institutions can be a collaborative mechanism, how can they be brought on a common platform, what can be the connectivity with one institution with the other, and what is the rehabilitation process. All these things need to be examined. Please do that exercise post after 4 weeks.
We'll do that and come back. Extremely grateful.
Item 31.
Please, your lordships. Your lordship, this is a matter which can be settled by this honorable court for once for all, my lord. Here the builder is rushing for settlement to the home buyer, and majority of the people have settled, my lord. Out of 534, 361 has already settled, my lord. And
Was this matter before Justice Narasimha, bench presided over by Justice P.S. Narasimha, where writ petition civil number 245 of 2025 was listed lastly on 21st April 2026.
I request Lord to issue notice note so that the state can also come, my lord, and
That bench will take care. The matters are there.
please.
Yes, item 33. ये इसमें भी मुझे नोट करो why this matter was listed before.
33, my lords, it is coming up again. I am addressing. 33.
Oh, that's 33. I was looking at the board. I'm sorry. Please, my lords. My lords, here, my lords had passed an order by which the statute was amended. My lords. Because the elections are on the 12th of May. And
by the way,
my lords, they were all people who had filed.
So what are their names?
My lords,
My lords,
I beg my lord's pardon.
the petitioner's name. My lords, there is a list
Yes,
you can pass on. In my case where I appear, there are two petitioners, my lords. One is Paritosh Trivedi.
Yes, I'm sorry.
I'll just give the other name also, my lords.
And in 33.1, my lords, there are 5 petitioners. My lords, there is one more petition, my lords, which is not on board, my lords. Because it's lying in defect notice, it couldn't come in the list. So there are 2 in this. So total there are 10 candidates.
We'll find the names at page 127. 127 has all the names. I'm sorry. Page 127 in Paritosh Trivedi, my lords have all the names. If my lords may take that.
Page 127
of the paper book.
There would be 10 candidates. Remaining were disqualified on other grounds of pendency of criminal cases.
No, page 127, what do you want to show, madam?
My lords, I only want to show those cases where the rejection is on the ground of being office bearers. That starts from serial number 9.
We want to know who are the petitioners before us.
My lords, the petitioners before my lords in my present matter is Paritosh and one more person. My lords, I'll just give the name. Manish Kumar Mishra.
My lords, and in mine.
Page number 6. And that my lords will find at serial number 9 and at serial number, Manoj Kumar Mishra, 18 and 14.
My lords,
and 14.
And in my case, my lords, they are Jaykant Mishra. That's serial number 10. Then next is Pradeep Kumar Tiwari, Brajen Dev Pandey, Naren Singh Jat, C.S. Chandel.
You are again not answering our question. Where are the list of the petitioners?
My lords, page, by SLP, page 6. Page 6 of the SLP. Page 6 of the SLP.
Cause title.
Cause title, my lords. Cause title.
Show us the website of this Facebook or anything of this petition number 1.
Petition.
And tell us why right now we should not issue criminal contempt of proceeding against him and get him arrested if need be. Because they think themselves to be over clever and they think that they can take the law in their hands.
Petitioner of,
And so are the other petitioners also.
they are not there, Manoj.
They are,
Other
they
petitioners are
think
not
of
there.
the horse smart as we don't,
No, they are not.
don't monitor what's happening.
Yes, other petitioners are not there.
Go, you
Lords may.
use abusive language against Chief Justice of India, you use abusive language against the chair president of the committee appointed by us, and you want to come to us to seek relief. Be dismissed with cost of rupees 1 lakh.
Petition, my lords, which petition?
My
My
lords,
lords referring
yes,
to?
my lords may
My lords,
clarify that.
clarify that.
Has indulged in
My lords, may I just
noxious
make,
campaigning, making false, baseless, scandalous allegations against Justice Sudhanshu Dhulia, former judge of the Supreme Court of India, as also other functionaries, does not deserve
My lords,
any indulgence by this judge.
insofar as the five
This is
petitions
accordingly
are concerned, my
dismissed
lords,
with exemplary course.
please give me an audience. Yes.
Now so are the other one also. We will tell you that how to contest elections.
1 minute, please, if my.
As
lords
if this is
would
a
mind.
private property of your
My lords,
family.
can I have just 1 minute of your time?
And who is this Jain? Who is representing that Jain then? Dhanya Kumar Jain or something?
My lords, he's been dropped. I am very sorry. That's why I wasn't able to understand. That particular gentleman my lords are talking about is not a petitioner in the present petitions.
He will not be, naturally, because he knows that we have already caught him.
We do not support whatsoever his scurrilous remarks and his statement. We have nothing to do with him. He is not a petitioner before my.
Both are all dismissed. That we don't entertain.
May just see the
But let
connected.
me just come to one aspect. There were some of us here who had already resigned
Right,
also.
in view of the fact that in most
My
of
lords,
the, in
my lords-
most of the states,
My lords,
the
just 1
officers
minute,
of the Bar
please. There is
Association
something
have
to
not been
be
able to
said.
contest election on account of the impeding conditions at that time. We see no reason to grant relaxation or the benefit of subsequent amendment to the in the case of the.
Don't mind. My lords,
All kind of nonsense there.
my lords, can I have just 1 minute of your time?
Thank you very much, madam. We don't want,
No, there is something.
our 1
to be
minute
said.
is more
I
valuable
request
for some poor
My lords,
litigant.
I request you, and I'm not on something which is this thing. My lords, first of all, he's not a part of it. Number two, there are members here, for example, like Jyoti Rai and others,
Yes.
who had tendered their resignation before my lords, the amendment came about. Now, when they went and filed the nomination, they were advised,
Challenge the election.
my lords, in
Challenge the
view.
election. You file election petition. Where is
My
the
lords,
problem?
but they had already tendered, and then when they filed the nomination, they
Yes.
were actually advised by the committee in the area that there was no need to do that. Therefore, they filed their nomination
Madam,
with an
this-
undertaking.
We will not allow these doors to be opened for those who misuse their black robes.
That's what that, yes, my lord, that's what.
Indulge in all kind of malpractice.
It's not one of us.
They think that they can browbeat the system.
Let's all may not be painted with the same.
All of them are-
One person may be doing, my lords, not all. One person. Yes, my lords, my lords may proceed against that person.
Forget about anything. On merits also, when other states have been deprived, why should have it?
My lords may call for.
Yes, very much. We don't
My
want.
lords may
We
call
don't-
for a
we are all
report,
luxury
whereas we
litigants.
are concerned
Yes,
and
my lords may not be prejudiced, my lords. These
With
5%.
the same brush.
Yes,
Please
ma'am.
don't taint us with the same brush.
All right, thanks very much. Thank you.
It can't be vicarious liability, my lords, with due respect, my lords,
We see
something.
no reason to enter to grant to treat the members of the Bar Association of Madhya Pradesh differently when other states have already been, in the other state, the office.
Hello, there is an answer to that. What
Yes.
the committee has done in one of the cases of a criminal this thing, the committee has overruled the particular challenge, allowed him to contest. Even that order is passed on
Yes,
Saturday.
I am passing a copy.
It's passed on Saturday.
And ballot papers have been amended.
And the ballot paper has been
This is a
amended.
copy.
I am only saying, my lords, I am even willing to resign today, as I had offered to resign.
We are not concerned about it, madam.
My lords,
Not
orders,
really
my lords' orders had itself come to a thing, the committee accepted it. My lord, send us to Justice Dhulia.
Thank you very much. The order will remain same. Now, next matter, 34. Yes, item 34.
My lords, I beg to appear for the petitioner, my lords. My lords, there are two FIRs, my lords. First was registered at Goa.
Go
my
and
lords.
find out.
And The second, my
Go
lords,
for questions before the High Court. Why are you coming to us?
my
No
lords,
case
my lords, this is, my lords for, my lords, this is for, my lords for
Thank
transfer
you.
of the matter, my lords, for consolidation of the
Very good
second.
question of transfer. You first commit crime in the different states, enjoy the luxury, and then you say transfer the case.
My lords, with respect, my lords, if my lords may see, my lords, no cause of action or part cause of action has, my lords, taken place at,
Thank you
Varanasi,
very
my
much.
lords.
If you have any problem with Allahabad, UP FIR, go and seek quashing before the High Court.
My lords, today I am not seeking quashing, my lords, I am seeking consolidation of the second FIR
No
with the
question
first,
of
my lords.
transferring.
My lords,
Thank
because
you.
my lords, may I make one request, my lords? My lords, here, my lords, my lords, the accused in the first FIR, my lords, after a period of 1 year, my lords, he has registered the second
That's why we are pointing out. That's why we are pointing out. Goa FIR, you don't have any problem. You have problem with FIR registered in Varanasi or Kashi, wherever it is now.
My lords.
Go and seek quashing of the before the High Court if you are so.
My lords, because my lords, 2 suits are already pending at my
Thank you very much.
lords, court at Goa, my lords.
All right, thank you very much.
I'm
Now,
grateful, my lords.
We have told you the facts. If you don't understand, what can we do?
My lords, delay may be pondered, my lords. There is
There is no ground to entertain this petition, Article 32 of the Constitution. The petitioner, if so advised, may approach the appropriate remedy.
my lords, a delay in refiling, my lords, may be pondered, my lords, with respect. I'm grateful, my lords.
Yes, item 54.
We're requesting for a passover in the case, Ms. Vibik.
Pass over then on some other date. Next.
My lords,
No, if you want to discuss, you can, you first pay to all the home buyers and then come to us.
Lord, it's
How many people you have looted?
not 1 year. Complaint has been filed. It's right yet to start.
First ensure the interest of the home buyers who are, they have been duped like anything.
We are before this honorable court.
We will not enter right down unless the petitioner safeguard the interest of the home buyers who have been explicitly duped. Why this court should entertain? Let the petitioner show as why this court should entertain the prayer in the petition.
Lord, we can keep it after 2 weeks. Lord.
Next.
We will file it.
Next item 55.
Wait, please, Manoj. All I want is my stay application to be decided. High Court has issued notice.
Go and seek up the application.
But the High Court.
Why this via Supreme Court?
Because the High Court is not decided. It's listed tomorrow, my lord, before the High Court. There is cognizance cannot be taken without sanction is a simple point. All I want the High Court is decided, reject it, allow it, whichever way. I'll come back to your lordship. Cognizance without sanction against a public servant cannot be taken. He is still serving.
Matter is listed for argument. You people are.
It's not twice over, my lords. Twice over. It was recorded in the first order of the High Court.
What is the next date, sir?
Tomorrow, my lords. Tomorrow.
Tomorrow, are you there?
My lords, lordship may only indicate, my lords. One
No
word
case
from
to
your lordship.
entertain Especially petition is made out, especially when the High Court is seized of the matter and the case is listed tomorrow for hearing. This must.
No, my lords, please kindly, my lords, just
Item 59.
My lords, may I withdraw it with liberty? Then that much may be recorded. At least something, it doesn't move, my lords, it doesn't reach.
Right. When Civil Counsel for the petitioner seeks to withdraw this petition with liberty to raise all the contention before the High Court.
Lordship.
As the matter is coming for hearing tomorrow.
Tomorrow.
Now, whatever order you want, we will upload that.
How can I say, my lords, sir? Oblige, my lords.
Yes, 59.
59.
Malas,
in this matter, what has happened in the recently concluded Karnataka?
Can't file election petition. Please don't. We don't have time to hold the inquiries and all this.
Lordship, may kindly see page number 71, then I give up. Kindly come to page number 71, Annexure P6.
Yes, yes.
We are only requesting that the committee may only look.
Lordship, may kindly have a look. There are handbags, there are silver coins, there are expensive articles, cash, UPI transfers which have been effected for casting votes against this thing, my lords. And we are not asking anything, my lords. We are just.
These are all question of fact, please.
My
File an election petition.
My lords, we have approached respondent number 3, the high powered committee. They have not done anything.
You may have a genuine grievance. And look at what kind of inquiry we can order, under which provision.
Manas, we have approached respond number 3, high power committee, then high power supervisory committee also. They have also not even acknowledged our case, Manas. Where do I go? Manas, my prayer is very simple, Manas. Let's come to the prayer. Manas, we are seeking a direction.
If they are not contesting the
You are
election,
not,
challenge an election.
you are not the
Are you
candidate.
contesting the election?
We are, all three are to participate.
So
We
you
are
file an
candidate.
election petition. You file an election petition. If there is a breach of
we
election
have-
rules.
Made a complaint to the high power committee. We have made a complaint to the supervisory committee. Nothing has happened. Manas.
Correct. When the
That's why-
result comes out, if you feel that these are corrupt practices and has vitiated the election of a
Yes.
candidate who has won, challenge it. Why should it be interdicted in the midst?
Manas, what am I asking? My prayer is very
Again,
big.
why should we interdict in the midst?
I beg your
In the middle of the election process, we will not interdict
I'm
anything.
not asking to stop the election process. I'm not asking to
Then-
stop the counting. I'm only saying that hold an independent inquiry.
Why?
Withheld
Why?
the result.
Why?
because
That
there had-
itself is an interference to the election process. If corrupt practices have been indulged by an elected
Not by
candidate,
this court.
you have brought it notice to the high-powered committee. This will be relevant evidence for you to lead and set aside his election.
High power supervisory committee has not even acknowledged our complaint. I'm only asking for a direction to the high power supervisory committee to conduct a fair inquiry. That's all, my lords. I'm not asking to halt the elections.
Sorry, sir, sorry, we can't. Please understand our limitations also.
And I'm just asking, I'm not saying that don't withheld the election or anything. I'm just asking that the result may not be declared vis-a-vis only city civil,
Absolutely,
only
result
city,
must be
not
declared.
entire Karnataka.
The result must be declared for you to challenge the result.
Malus, after the results are declared, nothing
Then-
survives.
Oh,
It-
nothing
the
like that.
pendency
Then
of
go
the
back
result-
go back and read the election law. The cause of action arises upon the declaration of result.
Once the results are declared, what survives?
Yes. Find out what survives, you will get the answer.
May I please, Your Lordship? Lordship, the AOR who have become AOR on this year, Your Lordship, 28th February, their results were out.
Got the AOR on 16th. Became AOR
Had
on
the registration been on time, Your Lordship,
16th May would be the-
had the registration been on time, Your Lordship, this issue would never have arisen. Their registration was done on 16/4, Your Lordship. Till 18/4, they have accepted the fee, Your Lordship, and many of these people, they have already paid the fees, Your Lordship.
Of registered members. They have accepted of registered members.
The registration fee has been paid, Your Lordship. The registration fee has
Registered
You resolve yourself. Why don't you, please don't rush to
Just-
item 59 order. The issues lay.
just their desire to be the part of.
Just a minute, please don't create confusion. The petitioners who are alleging electoral malpractices in the recently held elections of the State Bar Council in Karnataka have raised various disputed question of facts which cannot be gone into in proceedings under Article 52 of the Constitution. If so advised, they may approve the appropriate forum. Now come to item 60.
Yes, Your Lordship. Item 60, Lordship, what I'm saying, Your Lordship, that these are the new advocate on record, Your Lordship, they just are willing to.
Why are before you see that what kind of the solidarity and professionalhood is it showing that you are before us in a court proceeding? Why don't you resolve yourself while sitting?
Actually, Your Lordship, that should have been ideally the position, Your Lordship, when it was not done.
Who are you?
That is how we are, Your Lordship.
We are election commission,
Right?
5-member election committee.
18th,
Election board.
Yes, my lord.
18th, Your
So,
Lordship, they have taken the fees, Your Lordship.
so your lordship may straight away come to page 155.
Where is Mr. Vipan? You sit down. Where is Vipan and Amit? Where is Mr. Vipan and Nikhil Jain and company?
I don't see them present in the court right now, Milords.
Executive Council only has the right to appoint anybody, right to induct new members.
The treasurer.
क्या rights को ऊपर fight हो रहा है?
Milords, apart from the rights, there is another issue. They are not opposing the prayer, but the whole problem, my lords, most of the contestants, they don't know about these people. They are just new entrants to, so 207 people as a lot. Nobody has any idea about these people. So at least there should be some.
There is working on record now, your lordship. How can he say that?
There may be some delay on the part of the Supreme Court also.
Advocacy record.
My lord,
It is a shocking submission, your lordship. Who are these people? They have qualified the examination. Now they are advocacy record.
So there should be some time to canvass.
If I may just make one submission, Lords. As my friend said that apparently there is a WhatsApp group.
That court procedure I did on 16th. I could do it even before that also.
Yes, your lordship. This is what I am saying.
No, Lordship, they are not
28th
yet,
February.
they are not yet the members of the association. For them to be members of the association, they have to actually have an executive committee to actually verify and scrutinize their membership. Lordship, they are yet. And once they are not members.
Your lordship.
therefore,
And your lordship, on page 5, your lordship, some of the petitioners who have actually paid the amount is also given on page 5.
my lord, to put the records straight.
It's not them. After the Supreme Court scrutiny, your lordship, this part I am.
My lord,
An election committee has actually got complaints that there has been WhatsApp groups where
Right now,
there are three.
This issue of constitutional interpretation has arisen. So therefore, we will have to resolve it. Issue notice. Returnable so and so date. The respondents may file their reply affidavit if any. Meanwhile, the advocates on records who were registered on 16th April 2026 shall be permitted to cast their vote provisionally.
Much obliged, your lordship.
So, however, they shall not be entitled to contest the election.
my lord,
Yes, sir.
before that, this interference under Article 32,
Let the
somebody.
candidate go to their houses
Because, my
also.
lord, it will create a very
That
bad
will be
precedent.
different.
Anybody who is claiming that I should be included in the voter list will come by way of
Everybody.
Article 32 petition. And therefore, the judge just want to show the process of membership.
It's
It
all
is
like-
written in our constitution. If that is not followed,
Now go
your
and
lordship,
comply with this order.
your lordship may kindly see for a moment,
Item 61.
page 145, my lord. For one moment, your lordship may, because it will, they will vote,
Later on.
it will influence the election. Because the complaint,
My lords, I'll just mention, my lords, it's not the question of constitution. We are not interested much of the constitutional issues here, my lords. What happens, my lords, this 207 persons, I'll just explain, your lords, may kindly give me 2 minutes time.
I was busy in hearing constitutional bench matter. I would have formally called them even on 13th April.
True, my-
Maybe even before that.
My lords, we are not
My lord,
against,
that is not
one
the
second.
reason.
My lords, we are not,
my lord, that is not the reason.
my lords, one second.
Registration is not
Lords,
the reason.
kindly allow me 1 minute, my lords. Kindly allow me 1 minute, my lords. We are, your lords, may kindly allow me 1 minute.
Item
Your lords,
61.
My lords, kindly, my lords, we are not against the voting rights of these people. They have every right to vote. The issue, my lords, issue is this 207 person is standing as a block, and it has created an impression that we have facilitated your voting right as 207. Other candidates have no idea about this 207 person. They can tilt the voting. There is no level playing ground. There should be a fair play in democracy. There should be free and fair. So 207 as a block is being sponsored by the existing executive committee. They said, look, we are the people who gave you the voting rights. So all other people have no exposure to these people. They have no idea about these people. Who are they? So contestants, they don't have any idea about these people. So they will be en bloc voting against a particular candidate, and that is going to tilt the results, my lords. So there should be a free and fair election. That's only. Let them vote. After 5 days, let them vote. If the election is postponed for 3 days, 4 days, nothing is going to happen. We will get a time to speak to those people, impress upon them, and canvass.
If you want to postpone, you can postpone.
It's 5 days, your lords may kindly postpone. What I'm saying is only, your lords may kindly postpone or 5 days or 6 days. We will have a time to canvass these people. We'll have to talk to them.
That is within your right of
My lords, no, my lords, that is for the
committee.
yes, my lords, if that liberty is given to the election committee, they may take a decision, my lords.
Is always at liberty in
That
view
is-
of these changed circumstances to take up.
Yes, my lords, only time for campaigning, that's all I'm requesting.
and take steps for registration of these
It
members.
should be it should be an inclusive bar. It should be an inclusive bar association. It should be an inclusive bar association. Everybody should have vote. Even new members should have vote. We are not against their voting rights. They should also be voting. No doubt about it.
The election committee is very much before your lordship.
Tomorrow at 10 a.m. my lord.
My lords, no idea about this.
May I just submit, lordship? Lordship, the-
Extending 3 days or 4 days, my lord.
Order will remain same. You may argue for 1 hour. The order will remain same. Now please leave the court. Better.
Lordship, SCORA members may be allowed to intervene.
What kind of argument we are, I am surprised, I am so disappointed from the advocates on record arguing this plea. They are your family members. Only because of the administrative exigencies, I could not call them in court before 16th. You should have welcomed them.
It's not the reason.
My lord, that is not the reason. We are not against their rights, my lords. We are misunderstood. We are not against their rights.
Are you contesting?
We are
No, my
not.
lords, no, my lords, I am not contesting, my lords, we are functus officio, but the election commission is here, because it's a very sensitive issue, the stand we take. Either way, we get pilloried.
They are on the threshold of being inducted as members. Technically, they are not members, but for all practical purposes, they have complied with all the requisites for membership.
Yes, my lords.
In that situation, if we are permitting them to vote, there is some submissions made that there should be given some time interaction because the number of voters have suddenly will increase.
Yes.
That is up to the election committee to.
Yes, my lords. Absolutely.
Ideally postpone it for a week.
Yes, let the election commission take a decision on that.
Alternatively, the election committee may explore the desirability of postponing the election for 1 week.
Please, ma'am.
And complete the formalities of membership enrollment
Yes.
Please,
of the petitioners, namely the newly qualified advocate on record.
please, my lords. Deeply obliged. Deeply obliged. That's only concern, my lords. They have every right to vote, and we should protect them.
Your family.
Yes, my lords. They are young members. They are young members, and at least we should have some chance to talk to
The
them.
only difference is,
I thought, and so will be my brother, that SCORA is rather more possessive than the other SCBO.
my lord, this is a 2-year,
Programs, what else you want me to say openly?
this is a 2-year term, that was why the angst.
Should be member of SCBA.
So-
They should be
No,
member
at
of
least-
SCBA
my
to
lords,
become a member of SCORA.
At
first.
least they can
So
forget about the procedure for the time, my lords. We should not be bothered about the procedure, my lords. The constitution procedure, we have to take care of everybody. It's an inclusive bar association.
Please now mediate and get it
Look,
resolved.
last time I did, I was pillared on the groups, so we have to be very careful when we are dealing with the viewers. So one small, I'll be very honest, my lord, we gave us last time,
The election,
Yeah.
instead of 1 week.
But we will,
Yeah. No, it has been already directed.
for example, only done for a reasonable time.
Yes.
We leave to your discretion.
fair
Deeply
enough,
obliged.
fair enough.
Deeply obliged, my lords.
But result is, it doesn't look nice you that you people
My
are.
lords, we also feel bad, my lords. I'm so sorry, I apologize, my lords. But this is a situation, only for because everybody should be on board.
In any case, you can't be
My lord. But
he's an associate member.
I was
He's
an
associate member.
AR for years, and my friends came and please request the court at least.
He has his old sentiments attached to.
No, no, he's an associate.
Absolutely, my lords.
Old habits die hard.
No, I'm not against.
So there is nothing wrong there. But please mediate and get
Yes,
it.
my lords.
We will.
In fact, in this court, seniors won't antagonize AOs, my lords. But for a cause, we need to do.
Now do you know your strength?
Please, my lords.
3,996.
And active members.
No, these
They're
elections
all
are.
active members.
Yes,
Yesterday only at night I cleared some file and some.
yes. Almost like SCBA.
You are a
At par.
very potential bar association.
That's right.
Deeply obliged.
Grateful.
Deeply obliged, man. Grateful, my lords.
Item 61, the petitioner.
They are better than.
Petitioner's name has been wrongfully deleted from the list because his father was. I'm just praying for an identical order in page 76.
Yes, yes. Okay.
It is mandatory.
बुखार चढ़ा हुआ है
दोनों matter
जल्दी बुखार है सब
Lord, I am appearing for respondents number 1 to 13, my lord, in 35.2.
35 is this Punjab.
No,
Lordship. Urgent.
35.2, my lord, I am appearing for 1 to 13, and lordship had appointed a commission, my lord, for seeking the report. My lord, I believe the report has come. If we can be supplied with the report, my lord, then lordship can hear us after we peruse the report, my lord.
We are for the petitioners who had been kept out of the election process, which has resulted in the situation impugned before the High Court. And the High Court would place that as a fait accompli against us in the teeth of an order that's passed by the contempt court recording
Justice
the
Nirmanjit Kaur was the
undertaking of the learned advocate
Chairman
general
of the
that the
commission.
elections have been postponed.
They are
And that order is declared null and void in a writ petition filed by the people who claim to have been elected, but who had not been subject to the oath process or were not allowed to participate in the election process.
There are two districts involved, my lord, Patiala and Moga. I am for the Moga, my lord. Moga has a different case as per
Well,
the
let me will
report.
see,
Report has come, my lord, as per the office report.
no, there is nothing on the report.
Well, report says it has, the office report says it has come.
Page 4 of the office report.
Page 4 of the office report, if you lordship may kindly see.
Committee has sent the report.
This is the fact-finding commission.
The same may be placed before us in the chamber. And thereafter separate orders will be obtained for
Copy,
circulation thereof.
lord, copy may be supplied to us if
For
lordship may.
circulation of soft copy thereof.
Thank you.
Grateful, Lord. Grateful.
Post this matter on so and so day.
Grateful, lord.
Grateful.
Yes, item 36.
Yes, please. Lord. I beg to appear for the respondents. Your lordship may kindly fix a date as early as possible so the matter can be heard.
Salve may be unmuted. He is appearing on behalf of the petitioner. Lorships.
This, I hope the Lord can hear it.
The trial is fixed till 2nd of July is the last date for closing summons. So
I hope
anytime
Mrs. Salve will not mind by saying that let it be heard in May.
No, last
Lord,
time.
May I will not be able to come. Because the trial is day to day till 2nd of July.
No, Mr. Salve will not take it in July. The date has to be in May only because we are starting then again after vacation immediately we are starting 7 judge benches. So we will not be able to spare time. That for this matter, because the last date, that's why we said that 3rd week of May, we will keep exclusively for.
My lord, my only concern is this. I would have happily returned the brief and somebody else would have done it. Only thing is I've done it before the arbitrator's single judge division bench. So they'll have to find somebody else to do it.
You can do, you can argue online, Mr. Salve will absolute no difficulty.
I'm sorry, my lord, I couldn't hear.
Even if you are occupied and you can't come here, you are most welcome. You can argue online.
No, my lord, the timing is such. Here it starts early in the morning because it's partly Gulf time. It's being done remotely and it's going on day to day to 2nd July.
Mr. Salve, I have already notified the schedule of my CV. Constituent bench matters. I am starting 7 judge bench matters immediately after the opening in July. So
yes.
this is the only week left. You please make some arrangement. This is our request to you also. We will start this matter on 19th May, and those 3 days and then next 2 days are again available so that continuous.
Then your lordship will excuse me, my lord. They'll find somebody else to do it. I won't be able to.
We will request you, but in case you are in difficulty, then let some alternate arrangement be made, please.
Very well.
Very grateful, Lord.
Post this matter for final hearing on 19th May 2026. The petitioner side shall be entitled to is requested to sum up its submissions, to complete its submissions on 19th and 20th May 26. The respondents may complete their arguments on 21st of May. if need be, for rejoinder hearing, the matter shall be taken of 26th May 2026. Next paragraph. For all intents of the proceeding, the matter shall be treated as part heard. Next one. No adjournment shall be granted.
Grateful to Lord.
Item 37, please.
May it please, Millards. Millards is a transfer application. I may bring to your lordship's kind notice, Millards, barring the complainants, financial institutions. All the accused are from Hyderabad. All the witnesses are from Hyderabad. Beg your lordship's pardon.
Not a case for us.
Millards, I reckon even forum convenience, all of them are coming over here and facing the trial. Millards. The same CBI court could as well take care of them.
It's not a civil case. It's an criminal case. Investigation. There's no question of forum convenience.
No, I'm submitting, Millards. My lords may
The only
kindly hear.
argument of cause of action we have examined wrongful losses suffered by the complainant within jurisdiction.
Indeed, Millards. Millards, even barring the signing of the loan papers, the disbursement was in Hyderabad. The alleged misappropriation or diversion of funds was in Hyderabad.
If we look at it from the enforcement point of view, the enforcement of the funds were from accounts and of constituents who were carrying on their business in Delhi.
Millards,
So
entrustment
because
was in
of the
Hyderabad.
wrongful conversions, the complainant suffered wrongful loss at the offices in Delhi.
May I just add one thing, Millards?
We are not going.
The disbursement was in Hyderabad. The conversion allegedly was in Hyderabad.
And if you see criminal breach of trust, wherever the person is seeking to make the entrustment, so the transfer was from Delhi account to the Hyderabad account.
Millards.
And the money was required to be accounted for at the registered office of the complainants. So that way, there is a part of cause of action in Delhi. And
Yes,
the nature of investigation, we do not find it imperative, required to transfer.
Would my lords have a look at section 4 of PC Act, Millards, which mandates if it's been coupled with offences under PC Act, the trial should be, may I just pass on, Millards. Your lordships have decided a similar issue, if my lords would like to have a look at it, Millards. In my humble submission, almost on the same lines it runs. Okay, that requirement, section 181 of CRPC and section 4 of PC Act have been considered. And the lordships have concluded, Millards, if my lords could see, Millards, especially
a very old law.
para 31. Millards, the same has been, Millards, replica of the same provisions, Millards. PC Act has not changed. 181 has become 201 with all the parameters intact. My lords could see para 31.
Accused-centric, accused-oriented law is no longer is followed, and there are new dimensions where victim-centric approach is now.
No, I'm not at that point. Victim is an institution, Millards, financial institution. That's the government's controlled institution.
Where is the financial institution suffering loss?
Millards, it's been coupled with PC Act offences.
Correct.
Section 4 springs into action. That's what's been
This is
decided.
exactly when you see section 179 of the Code of Criminal Procedure.
Yes, Millards.
When a part of the offense includes wrongful loss, the place where the wrongful loss is caused is a part of the ingredient of the offense. So in this situation, where the financial institutions who allegedly were induced to make transfers
Yes, Millards.
from their head office at Delhi to the transfer and retention account in Hyderabad,
Yes,
from where the misappropriation takes place and the wrongful loss is suffered at Delhi, part of the offense is in Delhi.
Could my lords have a look at section 181 of CRPC or 201 of
Right.
201 of BNSS, Millards, where it's been said subsection 4.
We are reading it 181 with 179.
Indeed, Millards. So then, Millards, 181 is specific provision, 179 is generic provision where it's been spread across.
Where you are to account for, Mr. Naidu.
Yes, Millards.
The debtor is to account for at the office of the creditor. So,
If I may take 30 seconds, kindly have a look at subsection 4 of 181, Millards, which says that, may I read, Millards, any offence of criminal misappropriation or of criminal breach of trust may be inquired into or tried by a court within whose local jurisdiction the offence was committed or any part of the property which is subject of the offence was received or retained. or was required to be retained and accounted for. All these things have happened in Hyderabad.
For
Yes,
last 2 words.
yes, my lord.
Where were you to account for the loans that you had
My lord,
taken?
they have their branches in Hyderabad.
No.
The disbursement
No,
happened
no.
through their branches.
It's clear principle of law that the registered office is the place where you account for in respect of a corporate entity.
Last ditch effort, my lord.
So much.
Section 4 of PC Act.
No, no. One offense committed, all will run.
My lords have held in that judgment, Braj Mohan, the principal offense, which being the PC Act, my lords, the procedural aspect should follow in terms of that one. That's what your lords have held, para 31, my lords. But anyway, my lords, may I seek indulgence of your lordships that one of them is also a speaker of an assembly presently. Could they seek exemption of their attendance, my lords? Because my lords, when it comes to your lordships, big companies collapse spectacularly. This is the problem, financially though. Could my lords observe that aspect, my lords, so that gives, otherwise it's an embarrassment.
Thank you.
Great.
Now, let's put the matter because then.
The 38.
38, 39. All matters.
Very well. Very well.
Some urgent. There is a DPC meeting.
Your lordship.
My lord will be asking for the interim order for deal cover because it's international item 45. If your lordship kindly get the IA tomorrow, my lord.
Your lordship.
Day after it will become infructuous.
Lords 45, Lords has already issued notice. Lords, this is the DSP Haryana.
Here's 45. Yes. IA because I'm asking you some interim.
Your lordship, in item 44, there is a request for the withdrawal of SLP.
Withdrawal is allowed out of 12.
Item 45.
That notice please should be, it's coming up, notice.
Withdrawal है कोई.
Item 40.
I am obliged.
45, Milords 45, there is an urgency. Milords, the DPC is coming tomorrow.
Right.
Despite Lordships, the issuance of notice, Milords, it is coming on the 11th. Milords, may kindly see 45.
Item 45, your lordship will kindly take tomorrow, my lord.
Milords, 45 is of great importance. Milords, DPC, Milords, despite your Lordship's notice.
Possibly filled, all the whole is filled at 20.
Milords, state has gone ahead and issuing, Milords, notices for organizing DPC.
Thank you.
Lordship, I have filed an IA as last time I had mentioned, and this is regarding of course, the election, which is not the issue of the IA. The issue is that should the post of a president be confined to a particular gender, going on the line of reservation. I have filed an IA. Just Lordship, I may be permitted to submit. Lordship, so that is one of the prayer in the IA. This is IA number 67733 of 2026.
If your lordship take up the chart, my lord, which the secretary has prepared in terms of your lordship.
Lordship,
protection.
nodal
I think,
officer.
my lord, one by one, that will be more convenient. Issue will also be there, my lord, in that.
So the chart has, my lords, the EC suggestions, Justice Nageshwar Rao committee suggestions.
The chart is.
Lordship, the chart with time has become very academic because this EC, the tenure has again come to an end. And for the past 2 years, this is what is happening, that we have to come to your lordships for getting the election date declared.
My lords, may I
Their term is completing on 21st of May.
just point out with
Just a minute, madam, just a minute. First, where is that this Mukut Nath Verma?
Mukutnath ko
वो minutes देना आपने
Okay.
ये final है ना इसका आसन है क्या
Then continuation of order dated 6th February 2026 and 9th March 2026. Mr. Mukut Nath Verma advocate has filed a revised affidavit of unconditional apology and undertaking. Para 4, 5 and 8. 7 and 8 of the aforesaid affidavit are to the following effect. Next paragraph. In view of the unconditional apology tendered by Mr. Mukut Nath Verma to this court as well as to the members of the election committee and coupled with the undertaking given by him, with para 8 of the affidavit, from the interim order dated, the interim bail granted to him, wide order dated 9th March 2026, is made absolute. However, for a period of 6 months, the conduct of Mr. Mukut Nath Verma will again be assessed after a period of 6 months. For which purpose the matter is ordered to be, for that limited purpose, the matter is ordered to be listed on so and so date. Now come to the issue.
Your Lordship will recall, this is that Justice Nageshwar Rao's committee's report, and we had placed that report in our EC, and the EC has also unanimously given some suggestions to that report. That is in the form of a tabular chart for your Lordships.
Yes, that report by Justice Nageshwar Rao, thereafter the SCB has also.
Yes, we have given his suggestion in the first column and the EC suggestion in the second column, Lord.
There's a tabular chart, my lord, filed on 8th March. Yes, that's the tabular.
Yes.
In the compilation.
No,
of
first
SCB.
the compilation. First is very important, Lord, that the judicial direction should be incorporated in the rules. So far, it is not incorporated in the rules. So what is happening is somebody who becomes a member of the SCBA, he does not know what all is to be done for the purpose of his voting right. So that's the first suggestion.
Now we can consent to the executive issue.
Keeping the ensuing election, let us see what are the recommendations which require immediate attention.
Yes, so now, Lord, point number 2 onward, Lord, is the voting eligibility. First is advocates with 50 years in the Supreme Court in the preceding 2 years. We say no change to this. We only say that the 75% should be physical.
This first recommendation regarding
people are
appearances in Supreme Court.
That's right. That is the recommendation.
Your
We also
Lordship,
agree with that.
I had filed
Only
my aye, Your Lordship,
because
because
suggestion is not.
No,
This recommendation first.
Right to cast vote or right to contest election?
Your Lordship, right to cast vote and right to contest, Your Lordship,
to
both.
vote. This is
I
to
want a
vote.
relaxation in a regular membership so that they can contest and vote, both. There are two criteria. First, you have to be a regular membership, and then you have to come into the zone of right to contest and right to elect.
For becoming a regular member, you need
Lordship, if I-
Because it is difficult because there are certain differently able, I have communicated to them, like I had interacted. The few of them, they said, Madam, we don't have appearances, so how do we come in a regular membership? So if at all we can be considered as a 50%.
Lordship, before we come to that, on a larger
relaxation,
canvas, what
and
is
then
very
let me
important-
complete. I
Please,
mean,
please go.
if I
But
may
you-
complete.
Can I finish what
I
the
just want to surprise, which would have a bearing on the entire hearing. Regarding the right to vote,
the
Your
EC
Lordship, there is a judgment of the Honorable Supreme Court, B.D. Kaushik.
The main judge.
And that
Sixth
has,
appeal.
may I just? So that has been followed by the SCBA all throughout, and voting rights were changed and voting list was pruned. And
Mr. Gaurav
there is
Bhatia,
a
if you will wait
mandatory
for
requirement
you'll
of
understand. This is
50
a-
appearances,
Kaushik-
or if your proximity card says you've been coming to the court regularly, and many other criterias. Your Lordship, on a larger canvas, as a stakeholder like any others, it would be in the interest. I've seen the Justice Nageshwar Rao report, and it is a very comprehensive, very well-meaning report. Most of the members actually agree with the suggestion, but keeping in mind that this is a society and there are rules of the society, it would be a very good exercise at least once if all the members are also given an opportunity to present their views, suggestions, because the executive committee, while it is part of the rules, can have a view to it. I think there are very many members who will also like to give inputs to the suggestion of Justice
Mr. Bhatia,
Nageshwar
you
Rao,
are not
subject
aware
to
of
what this
this
bench.
meeting. The court has given enough opportunity to every member of the bar to give his suggestions. 5 times this court has given opportunity. So please don't
before the
interrupt the
report goes.
proceedings. Let the proceedings go on.
We directed them to be uploaded on the website.
Yes, Your
Yes,
Lordship.
yes.
Yes, there were two orders been passed. There are two orders been passed.
If my understanding is correct, Your Lordship, that suggestion was asked for before the report was submitted.
No, Your Lordship, it was after the report.
You are not aware. You
Then I
just
stand
entered the
corrected, Your
proceeding,
Lordship.
Mr.
But at the
Bhatia. You are
same
not
time,
aware.
it would have to be done through the general body also in a particular time frame that may be fixed, because it would then give sanctity to the rules as well. And as the process
is enshrined in the rules of the SCBA
Yes,
also.
because
That may be kept in mind. And if there is
Not aware.
something very urgent, then we bow down to whatever this bench, honorable bench decides, Your Lordship.
Your Lordship, I'm asking
Lordship,
for.
may I point out to Rule 21?
After the earlier judgment of this court in BD courtship,
Yes.
that judgment was in the year 2010.
10-11.
10 and
11.
11.
11 was conducted under that.
11. Yes.
2010 to 26.
Yes.
There is a sea change
Yes.
in the face, composition, working style,
Your Lordship.
everything in the Supreme
Yes.
Court.
Absolutely.
In 2010-11, the virtual hearing was nowhere, nobody heard of it.
Yes, Your
Now
Lordship.
today virtual hearing there, people are appealing through virtual hearing.
Yes, Your
So all
Lordship.
these issues, therefore, at that time, probably, the security was also not such a big issue, that proximity card and all.
No, it was there. That was there since
May or may not.
2009.
We are only generally
Yes,
talking about.
yes.
If your lordship go one by one,
Lordship,
this chart will not, perhaps that will.
Lordship, the stage of the chart.
That some reform with the passage of
Yes,
time.
it's a reformation, Your Lordship.
Yeah.
More bar inclusive, Your Lordship.
After EC has come, Lordship from 2011.
Inclusiveness of the
before
society.
that, Lordship, there has been no amendment in the rules, and therefore Rule 21, may I just read 21 of SCBA rules, Your Lordship?
Place the chart.
Like this, everyone then will
No, I'm saying.
get up and scope this matter. If you are, one by one, we'll have to hear.
Yes.
Definitely, Your
My
Lordship.
lord, there are 2 or 3 things which require importance, my lord.
Yes.
One is if your lordship come to my lord serial number 10 of this chart. Now, everybody, my lord, there is a requirement of minimum 50 appearance, 50 entry or 20 appearance, my lord. For senior advocate, there is none. My lord, we feel, my lord, as an election committee, we have suggested and there is no counter for it. Senior advocates also, my lord, there should be minimum appearance of 25 appearance to be in the last 2 proceedings. That's necessary, my lord, to be included in the voter list. When a non-AOR has, when an AOR has, when, my lord, everybody is required, a minimum appearance, senior advocate should also be. Another important thing is, my lord, serial number 13, if your lordship kindly see, my lord. Now, presently, my lord, there are 9 executive members. Anyone can become, my lord. What we have suggested, there should be category, my lord, so that all sections can come. Up to 10 years, 3 posts. Between 10 and 20 years, 3 posts, and above 20 years, 3 posts. Otherwise, what happens, my lord, the junior members may not get the opportunity senior members get, or senior members may not get. So this division may be necessary, my lord. And what is most important is 14 also, my lord. 14 is, my lord, Justice Nageshwar Rao committee is also recommended that for the post of president, there must be 10 lead appearances resulting in judgment. Similar thing is, my lord, SCBA has also felt is execute a minimum of 20 lead appearance in reported judgments in the last 10 years. What we have suggested as an election
This
committee.
suggestion at serial number 13 appears to be good. What is the opinion of the SCBA? And
20 appearance they have said.
No, no, for 13 my lords, no, just one second. 13 my lords, we have actually gone by what was earlier, no? Yes. Yes.
Earlier.
13.
On 13, my lord, presently 9 posts, anybody can come, contest on any post, my lord. Whomsoever gets the highest, subject to women representation, it is there. What we are suggesting is, my lord, let there from each category, my lord, so that the younger member of the bar may also come, my lord,
will not get the chance. Sir, young member will not get.
Can we? No, there is a category of up
If you lordship permit, can we go clause by clause? my lord?
That's what I was suggesting. And serial number.
Roll now.
Electoral roll, Lord, as per the bylaws, it says February it has to, the last people who vote up to February, and May is the normal time for election.
So now this year, May is the election.
No, this year it will have to be July because our EC, if your lordship will recall, there was a recounting for
last time there was some issue with regard to election of the
junior
Member executive.
When was that resolved?
That was resolved
July.
19th of July. So this is our EC resolution. We have said that we will hold it in July.
Lordship, we may be given a copy.
Your lordship, in terms
We should
of
be served a copy.
voters,
Resolution.
28 Feb is the last date to deposit your subscription.
That has not
On the
changed.
basis of that, a voting list is prepared in the month of April and May when an election committee is constituted by the election.
22nd of April.
Lordship, this EC should have amended the rules. This is what is my respectful submission. The EC, after EC has come, there has been too many C changes, but the rules remain the same. So as per Rule 21, it is 15th of May. Until they don't amend that rule, their tenure comes to an end on 21st of May, 20th of May.
We are not bound by your rule. Your rule is not something that.
Your Lordship,
Lordship, it's a society which is guided by the
If your
rules that
Lordship
they have,
sees
but
a-
they have not amended the rules. This is what I'm pointing out.
Don't downgrade yourself to a society. You have a very larger role to play.
In society,
the administration of justice.
the society
But
of the
we
country
registered under the Societies Act.
Now, if your Lordship will see, we actually, the office bearers were against Lord Delay, but unfortunately, 9 people had got elected in July, so we went by majority. So, apart from 4, everybody else felt that it should be held in July. So, if your Lordship will see, majority members are of the view that election could be held only after completion of 1 year from the date when full executive committee was constituted in the last week of July. Then, if your Lordship will recall, there was an issue of senior member also, women. So one senior member woman said that one has made it on merit, so I should be given one more. Your Lordship rejected that. Then your Lordship will come to the next page. On 24th of May, there was a recounting on the president. Of course, it didn't have any material bearing on the result. But ultimately, your Lordships on 26th directed that the counting of junior members be held in July because the court was going in recess. And ultimately, on the 19th of July, the results were declared and it was told to your Lordship on the 25th of July. So after that, Lord, the election committee started functioning. So the full EC started functioning. So we have said that we will, upon reopening, we will constitute the election committee and have it as soon as possible thereafter, giving the statutory timeline for holding the election.
We may not reduce this now. Women members of the bar this time.
Lord, your Lordships, I think, had reserved the secretary. That's a very good step, Lord.
Your Lordship.
And as far as senior members are concerned, 1/3 of that, which makes it 2, because there are, 9, so makes it 3. And for junior members, Lord, also 3. No, senior members 2, sorry, 6.
And
Senior members 3 and junior members 3. Senior members
And
2.
one of another important, Lord, the term which Nageshwar Rao committee has also suggested, and Lord, it should be 2 years, but the 1 year is too less a period. All bar associations across the country is mostly 2-year term, Lord.
So
Now,
can I take your Lordship's point wise? Because point number 2 onward is this recommendation. First is Lord 50 appearances. Our is the 3rd column.
Your Lordship, mine is 5th one, Your Lordship.
Can I finish this? Then you can, everybody can argue whatever he has to say. So here, Lord, there is an issue, if your Lordship will recall, last time I had checked up, there is one person who's living in Lord Agra doing marriages, and only because virtual appearances were being logged, his DP said rishte hi rishte. So I've said 75% should be physical and 25% virtual, and that physical can be measured by the proximity card entry. So for the time being, there is no issue. We can straight away implement that. If you have a proximity card entry, and if you have enough physical, that should be sufficient for you to qualify for this year. Till your Lordships upgrade the software, which also I believe the registry is ready to do, which is not aligning the appearances with the proximity card and the virtual, so that the software will indicate that whether you joined virtually or you joined physically, it will be very clearly established. So that can come for future. But for this year at least, it can be done on proximity card. If your 75% of your appearances are on the days you visited Supreme Court, I think this should go ahead. Then Lord, 3rd is AORs as per 20 filings, we also accept there is no change to 3rd. Non-AOR also, Lord, we don't accept this serial number 4. Your Lordships had said, Justice Nageshwar Rao said, none are members of the panel of mediators for 2 years with 20 mediation cases in 2 years. So that in the Nageshwar Rao committee said, added the qualification that mediation should be undertaken by the member as the lead mediator and not as a trainee. So this is accepted by us. So that is serial number 4. Then new category which they have done is veteran members holding membership for 25 years. This, according to us, will open a huge Pandora's box. A lot of people are members here, but they don't come to Supreme Court at all. So we have only qualified this by making it 30 years and who voted in the last 7 years out of 14 years. So that will be at least people who are still regular in practice. So this will not, otherwise this category 5 itself will take about 20,000 people. Then chamber allotment, this has been, they say removed it. We also say it could be considered provided there are 20 appearances, because a lot of people will not have chamber allottees but they've sublet the chambers and they are not coming to Supreme Court at all. So if they are having appearances, they should continue, according to us. This is the third is our recommendation. Waitlisting for chambers, it is removed as a category. We accept that. It should be removed. 50 appearances in preceding 3 years for government council, remove as a category. We also approve, Lord. Use of proximity card 60 in the preceding year. This the committee says remove. We suggest something else. Proximity card into Supreme Court should be considered, provided the members have entered the court premises at least 60 times in a year and at least 20 appearances. What is happening, Lord, is that there are people who just come in and go out. PCSRE voters, they come in, just go out to show the proximity card and go out. That should be curbed. So only proximity card should not be the only basis. At least 20 appearances. Otherwise, it is 50 appearances. Proximity card, we say 20 appearances. So that they should be at least coming and sitting here, at least doing something. It can't be blocked that they are just outsiders completely. Then senior member is a serious issue, which Mr. Vijay Hansaria also has raised. Senior members in the whole NCR, regardless of appearances, etc. So this is to be removed, and we also accept this. He has suggested, Mr. Hansaria has suggested, must have 25 appearances in each of the preceding 2 years. This could also be done, but according to us, Lord, they will come in the other category in any case. So this could be, your Lordship will have to take a call on this court category. The non-UR members and the Micus Curie panel, this has been removed by the Nageshwar Rao committee. We also accept that. Then, Lord, eligibility to contest. This is very, very important. 13. The Nageshwar Rao committee says 5 years permanent membership as SCBA should be mandatory for contesting any post. Committee did not accept supports increasing. We have accepted this. I think this is very fair. This should remain.
There is some suggestion on our.
And Mr. Hansaria has made a suggestion of creating 3 categories post-wise. That is for your Lordships.
ABC 3 category.
Yeah. Yes, ABCD. That is for your Lordships to take a call. Then, Lord President, the Justice Nageshwar Rao committee had said 10 lead appearances in reported judgment. We said 20 lead appearances in reported judgment. And he also, Mr. Hansaria also suggests 20 lead appearances. Because ultimately, he should be a practitioner of this court, Lord. It can't be that somebody who is a complete busybody with nothing to do with this institution becomes president of this bar. That is something which is a big concern for the entire bar, Lord. So it should be 20 lead appearances in reported judgment. And your Lordship knows, Lord, reported is not, Lord, even if you are on SCC online, it is still not reported unless it is reported in the SCR. Then Vice President, the committee has recommended, we say 10 lead appearances.
Each of the preceding 5 years.
No, we said 10 years, Lord. No. Last 10 years, total last 10 years.
So, but your suggestion is it?
Our suggestion is 20 lead appearances in the last 10 years.
10.
Put together. So you could have one reported.
Committee says each year 20.
This
can't be 10 years put together. It has to be.
This is our recommendation.
I'm saying, I do not know why.
They have said 10 reported in 10 years. We say 20 reported in 10 years. I think that should be fair, Lord. Reported judgment is not easy to get, and if you make it every year, then probably you will be having only Mr. Rodgi and Mr. Abhishek Singhvi and myself and 4 or 5 of us.
President as well.
4 or 5 of us only eligible to contest.
Mr. Bhatia.
So it will be.
But Matlab, there has to be some minimum lead appearance. Look, the president of the bar, he represents throughout the country. He expresses views
across the, my lord, on various issues in public platform. A president
And he
of
has a
power.
voice in the entire
He has a
country.
voice in
I
the
don't think it should be left to anybody.
It should not be, my lord, just two reported appearances in a year. It would not be sufficient, my lord. At least there should be 10 appearances, my lord, in
No, in a-
reported judgment. Otherwise, my lord, the president of the bar, my lord, represent the country, represents your lordship, my lord, sir. Before coming before lordship, my lord, on serious issues. He represents before the parliament on serious issues. Their
Vice
views are taken
President-
very seriously.
Lord Vice President, the committee has recommended nil. We say 10 lead appearances in 10 years. Lead appearances in 10 years, reported judgment. Secretary, they say nil. We say 15 lead appearances and 60 proximity cards. So this is not lead appearances as a reported judgment. This is just the lead appearances. Joint Secretary, Lord, 30 appearances and 60 proximity.
President, just coming back again to President, whatever, suppose 10 or 20 leads appearances there, for women candidates should be slightly relaxed. Because
Yes, Your Lordship, that's my
Your Lordship
humble
can do that.
submission,
You
Your
have no
Lordship.
difficulty.
It can be relaxed and even for the differently abled
Lordship, will be 50%.
person.
because all
also.
citizens,
Quite-
Yes, Your Lordship.
Very fair.
as senior counsel there.
Very fair, Lord.
Yes, Your
So
Lordship.
let it be 50% for women category.
highly
It is
obliged, Your
supposing
Lordship.
20 for lead appearances for president, then it should be 10 for women category. Lead judgment. These are reported judgments, Lord, not appearances. These are lead reported judgments. Lead reported judgment. That's important, Lord.
On lead counsel.
And that relaxation will continue for all other.
That can continue. Yes, yes. I agree, my Lord.
What we have
That can-
said is 20 as lead counsel, 10 as reported judgments, my lord.
No. We have said 20 reported.
Anyway, that is your subject.
Justice Nageshwara has said 10 reported judgments as lead counsel in 10 years.
That is,
We say 20 reported judgment as lead counsel in 10 years. My friend says, which is much stricter, which I don't think will be very fair because otherwise a lot of people, very few people will be, only 5-7 people only will be.
At least there are hundreds of.
Then Lord Vice President, your Lordships have already seen. Secretary, your Lordships have already seen. Joint Secretary, Senior Executive Member, we should say 20 appearances at least, senior members. And then Lord 20 is the term.
So for secretary, it's not clear whether it's in the year. It should,
And then
should be
20
10
also includes, Lord, the recommendation with regard to having simultaneous elections. If your Lordship will see the second part of 20, it is also recommended that holding of SCB elections on the same day as Delhi High Court and District. This is the recommendation of the committee of Justice Nageshwar Rao.
Secretary, we are not giving the year because we are not giving judgment, she was saying.
Secretary is only appearances, Lord, not Lord reported judgment. Not for the any other position. Only for the president and vice president are reported judgment. So 20 is the 2-year term and the simultaneous election. And 21 is the reservation, which your Lordship have already reserved. We also accept that for the EC members. And then Lord 22 onwards are some model code of conduct, which we all completely agree, Lord, as far as the EC is concerned.
Sir, one clarification related for vice president, that before he is designated, because the vice president, the candidate contesting may not be as old as 10 years. His designation may not be 10 years old. So this 10 years, 10 lead appearances in reported 10 years, then he has to be a senior designate at least for the past 10 years. So it is not clear on that.
No, appearance can be even as non-senior.
He can have a reported judgment.
So then that should be clarified, that it is his appearance, irrespective of whether he was designated.
Ms. Das, it doesn't say as senior advocate.
It doesn't say.
And need appearance.
No, it doesn't say. It doesn't say.
It takes care of your problem.
But then it's silent. It's silent on that.
In fact, if your Lordship will recall, a lot of us in this court have had a lot of reported judgment prior to becoming a senior, including Mr. Salve, Mr. Gopal Subramaniam. So all of us have had a lot of, even Mr. Nariman.
No, there is a
So lead appearances should be good enough according to me, Lord, as far as the reported judgment is concerned. Reported judgments, lead appearances.
one suggestion, Milods. There is a large number of lawyers who are involved in paralegal activities, who are drafting laws, who are doing translation work. They may not have the appearances, Milods. So their interest may also be protected by considering the number of appearances, because they don't actually appear, but they are the part and parcel of the system.
That
They are
will be a
doing
little
drafting, they're
difficult
doing-
to
they are-
regulate.
Your Lordship, one of the
So the plus
suggestions.
is lawyers will
Among the lawyers, there are no paralegal volunteers.
There is no
Paralegal volunteers are non-lawyers.
lawyers who are,
Your Lordship, one of
Lordship,
the.
one aspect which is not covered.
who don't have
Lord-
appearance laws.
Lordship, one aspect which is
Your
not
Lordship,
covered is
one of the-
temporary
one-
membership. No other bar has the provision of a temporary membership. In Supreme Court, after 2009, there is the temporary membership.
Your Lordship.
So that is not covered because a temporary membership has to give 20 appearances in 2 years. And if he wants to get included in the voters list, he should have 50 appearances in the second year. So that again needs to be clarified because temporary, for 2 years, he is there, he is with a senior or he is appearing on his own. But once he completes his 2 years, then if the 2 years is at the end of the year, it is disadvantageous for him. Because that cannot be, he cannot become a voter. If it is at the beginning of the year, so the year that you become a voter, you need to have 50 appearances for that particular year, irrespective of the fact whether you were a temporary member at that time or you were a permanent member. So that is completely, the suggestion is completely silent on the temporary membership. This started because of certain reasons, certain developments had taken place in 2009. I will not, Justice Vishwanathan might be recollecting also, this was the Supreme Board of Management. And which started with this thing that there should be temporary membership.
Are temporary members also voters?
No,
No,
they
Your
are not.
Lordship, they are not. They are not.
They cannot become voters.
So
They
that's why,
cannot-
Your Lordship, my humble.
Lordship, it takes them 4 years to become voters because for 2 years they appear as a temporary member. Then the
For a
year that,
temporary
they have
member,
to
become a
become a
full
voter.
member, he needs
For
20
purpose.
appearances.
There are
2 years.
2,000
In a year.
earlier in 2011, 2,000 voters after the BD coaching.
2009.
And otherwise, there are more than 13,000 members.
No,
So
there
the
are
bar-
23,000. No,
allow me to
my
complete
friend is
point.
not,
I'm
no,
making
23,000 members.
Lordship, factually,
I'm saying
Lordship, factually.
2011, when the
No, it
Supreme
was
Court
2000
judgment.
it was
So the
2009.
reason is this, that
For a-
practicing lawyers get to vote and elect their representatives. That is why there are two categories. And it should be well maintained to keep the character of.
No, Lordship, I'm not
Your
on that.
Lordship,
There must be two
one-
category. What I'm submitting is that a temporary member, if he becomes a member, temporary member in 2006, say in the month of April, his 2 years will complete in 2028, but cannot be a voter for 2028. He cannot be a voter for 2029 also, because for 28, he has to give 50 appearances. So suddenly from 20 to 50, that must be under consideration. That
No, I'll explain.
50 members, if they are new members,
So when
that
you
aspect
become a
is complete.
permanent member.
And Lordship, what the EC does, in fact, we've all been a part of the EC at some point of time. It is the subscription is taken full by the temporary membership or any applicant who applies for a membership. The interview is held a month or 2 months or 3 months later. And then, his appearances start. So that this whole process of taking the money, then his appearance should be counted from the very day he submitted his application form.
So I'll explain, Lord. So supposing for becoming temporary to permanent, if you have 50 appearances, you can straight away become a voting member. So that's not an issue.
Lordship, it is difficult. It is difficult for a new member who is.
But that's why this 50 membership
Lordship,
appearances have.
Lordship,
get
Mr.
only to
Vikas,
sell-
his parameters are different. His juniors must be getting 50, 500 appearances.
Otherwise,
But I'm talking about the general advocates in the bar. It all depends on which chamber he is associated with, how many matters
He
the
will
chamber
still get
has.
it in proximity card. I don't understand. If he's coming to this court.
Proximity card he gets 6 months after his application for a temporary membership is cleared. He does not get a proximity card the day he applies.
You can
Lordship,
get a
it takes
proximity card
it takes long time. It is only after the interview is held, he is admitted as a member, as a temporary member, then the proximity card takes another 2 months.
Card can be given
So
to a
4
non-
months of an advocate who wants to
card is
practice here, and after 5 years he is eligible for AOR exam. So his entire exercise is either to wait for that is 4 plus 1 years, or temporary member. There has to be some rationing on. It cannot be 50 appearances for a member who has become a permanent member. For first year, it must be relaxed to 20 appearances. That is not touched at all. That aspect is not touched. And Lordship, second thing is that
Proximity
since the
card
tenure,
does not
since this EC has decided, Your Lordship, that the tenure extends to July, we have no issues with that. But then why is not a general body meeting conducted? I'm sure Mr. Vikas Singh will not let it happen like 2024. Let there be a general body
Your
meeting.
Lordship had
After all,
recommended a general body.
Lordship, I'm
My friend is new in this.
again repeating that whatever are the issues, it concerns the member at large.
even those who are not regular members, regular
Women
practitioners.
representation, your lordships had asked for a general body, it was rejected.
Because here what happens?
Almost like
Lordship,
80% votes rejecting.
Lordship, any scheme that is introduced to a voting member. So voting member is only a member who has so many appearances. Someone who has paid the fees, if he doesn't get a brief, that is not his problem. Every lawyer in the country cannot be a lawyer holding 50 briefs or 100 briefs a year. We ought to have thought about the temporary members who are very much here. They don't go to any other court because their whole anxiety, am I going to get 20 appearances? And he is chamber attached or he is a senior attached. So it depends on how much work the chamber has.
It's a non-issue because you can.
No, it is not a non-issue. It is a non-issue for, it can be a non-issue for any lawyer who's been here for good 30, 35 years. It is a non-issue for me, your lordship. It's not an issue. It is an issue for those who have taken a temporary membership because that was not there. And even the rules have been amended for temporary membership. So if I look at the rules, why can't either EC should amend the rules?
Proximity card, my lord, can be given to a non-member also. Proximity card.
Lordship, the proximity card is given 120 days minimum later than the date of application. I'm making a statement at the bar. Any new member will testify what I'm saying. It is not given the first day. He makes an application, the interview is
There are
conducted
a lot of
2-3
Chennai
months after
advocates
the
who are
interview.
not members here. They are also having proximity card.
Your lordship, may I just submit before the order is dictated? Your lordship, one, a middle path needs to be taken only for the reason. The main purpose of the entire BD Kaushik exercise, as well as the suggestions by Justice Nageshwar Rao, whom we hold in very high esteem, is that regular practicing lawyers have to participate. But it cannot be so stringent that regular lawyers who are coming here, maybe they are assisting, maybe they are not appearing before the court and their appearances are not marked, are left out. Your lordship, may I just submit as a test case? I see the president and the vice president criteria. And I very responsibly say this, that 2019, after 4 years, we saw senior advocates being designated. Many of them were very capable. They had 50, 60 reported judgments. That's the reason the Honorable Supreme Court, full court, felt that they ought to be designated. Now, at this juncture, from an AOR to a senior advocate and from a senior advocate to be a flourishing senior advocate like Mr. Vikas Singh, it takes time.
Yes.
Now, if a person has been designated as a senior advocate of the Supreme Court, I'm sure there are many who are doing their best, they're appearing, there are appearances, but not 10 judgments or 15 judgments. But if you look at their entire career of 20 years, 25 years, you will find 50 to 100 reported judgments of those very people. Is the intention to exclude them? Or is the intention that young leadership is also groomed as vice president and president and they are able to adorn that task? Your lordship, therefore I say, suggestions are very good.
Even prior to becoming senior is counted.
Make my submission, please. I also speak for the bar, just the way my learned senior.
10 lead appearances in the last 10 years.
Your lordship,
notwithstanding whether you swear or not.
All that I'm saying is, if my experience, BD Kaushik came.
Not as senior.
No, I know.
In any capacity.
Reported judgments as a lead counsel, your lordship, is not easy. Lead counsel I'm talking about. I may be the second, third, fourth, because now I've become a senior. So there are other seniors within the senior advocates who are leading. So I'll never be a lead counsel.
As a non-senior, you show up.
As a non-senior, yes. That's why I'm saying, if a senior advocate who is being designated by the Supreme Court, does he need to fulfill that criteria? 1, 2. Very importantly, your lordship.
Your reported judgment, non-senior is also included.
As senior advocate.
I'm sorry, your lordship. Also.
It is not necessary that you require these 10 reported judgments as senior advocate.
Yes, your lordship.
For example, senior somebody became 5 years back.
Yes, your lordship.
Even before that,
yes, your lordship.
He has led in some argued some matters. Even those judgments are.
Lordship, they will not be leading judgments. They will be orders. They will be orders.
If it finds favor with your lordship, BD Kaushik judgment, after that, lawyers came here and they said, if we have been designated by the Supreme Court, do we need to prove that we are part of the system? And this honorable court, by a subsequent order in BD Kaushik only said that senior advocates, and then they included
they'll
the
be
NCR term,
Yes.
which can be confined to senior advocates of the Supreme Court, designated, need not meet this criteria is what I'm submitting, only because their examination
That is
has
only
been
for
through
voting.
the full court, and then they've been designated as senior advocates.
That is for voting purpose.
Might lead to discrimination among the senior advocates.
That's right.
Your Lordship, but in any case, if we are fixing, and everything is subject to Your Lordship, because Your Lordships are equally also well-wishers of the bar and the system, Your Lordship, but I submit, speaking from experience, say there is a judge who is retired from the High Court.
Right now, we are not taking it as an adversarial litigation.
Yes, Your Lordship.
Even whatever suggestions from your side are coming,
Yes.
idea is only to bring certain reforms that
Yes,
is required.
That's very important.
The elected governing body should really represent
Yes.
the
Inclusive bar.
Yes.
the true professionals,
Absolutely.
those who are work may be less, work may be more,
Right.
but those who are at least committed
Practicing.
as whole timer to the profession.
Right.
The idea is only to recognize bona fide members of the legal fraternity
Of this
as the voters, and again among them only to confine the eligibility for contesting election.
Yes.
That is the only entire.
Yes.
Lordship, if I may, if
But
I
Your
may
Lordship,
apprise this
why
bench,
you are
honorable
going
bench, Your Lordship, there are 15,000 members of Supreme Court.
Bench. No.
Lordship,
Still be required to furnish this is the point.
Lordship,
That
for
moment
ACBA,
Supreme
ACBA,
Court designates a senior. It is an honor bestowed upon a senior. Would he not be eligible? to
Order
contest
doesn't
as
make
a
you
president?
Lordship,
Point
may I just point out the larger issue? Today on record, there are more than 15,000 SCBA members. Voting members are about 3,000 or 3,000 to 3,500. Any scheme which is floated by the SCBA is confined to the voters. So voters become so important. Therefore, I'm submitting that the temporary members, their appearance to become a voter should be confined to 20 appearances like it is during their tenure. They should be included. Thereafter, you lay the criteria that you should have 50 appearances. It is fair enough. But not prior to that. I'm not on the amendment or the relaxation of the rule. And Lordship, one last submission, that this executive committee,
With a view to bring reforms in the election process of the Supreme Court Bar Association, this court first time stepped in on judicial side to a judgment dated July 20, 2012, rendered in civil appeal number 3401 and 3402 of 2003, in bracket Supreme Court Bar Association and others versus D.D. Kaushik. Thereafter, endeavors have been made from time to time to bring further reforms, especially when there was a dynamic change in the legal profession during COVID-19, where this court and various high courts, high courts and various other courts introduced virtual hearing, where the members of the bar were also permitted to appear online. Even after the COVID offset, the technological infusion providing online platform to the members of the bar have been further strengthened. Today, the Indian judiciary is proud of the fact that a large number of members of the Supreme Court bar from the high courts on pan-India basis prefer to appear online before this court and other courts. Next paragraph. Taking such like issues in view, say the online appearances also led to some other challenges regarding the physical appearance and or actual assistance to the court by members of the bar who want to become eligible to exercise the right to vote and or contest elections of the bar association. Also, These like challenges have led to initiation of a filing of various miscellaneous applications, IS/MAs, in the above mentioned, in the above cited decided case, in which various orders from time to time were passed. Next one. This court on what is the date when Justice Nageshwar Raw's committee was constituted?
What day?
On 7th February.
Nageswaran's
Report.
report was last year.
To prosecute a high-powered committee, named the Jana Committee, a high-powered committee to recommend reforms in the electoral reform in the with reference to the election of the Supreme Court Bar Association. Honorable Mr. Justice Nageshwar Rao, the former judge of this court.
24 to 25.
24
to 2025.
That's right. And report came in April 25. No, report came in April 22nd April.
Graciously accepted the responsibility. He was provided with assistance of members of the committee.
नहीं ये तो कबीर कौन
Next one.
ये तो मेरे पास है
Justice Nageshwar Raw's committee thereafter made certain recommendations, which were
पंचाल का जजमेंट
pursuant to the orders passed by this court were
पंचाल
displayed on the website of the Supreme Court Bar Association. The purpose was to inform the members, each and every member, to inform the members of the bar regarding the proposed reforms, as also to invite their invaluable suggestions. Next paragraph. This is a matter of report that pursuant to the suggestions invited by the Supreme Court Bar Association, some of the members of the bar gave such suggestions, and this SCBA has collated those suggestions along with those
Of the
recommended by Justice Nageshwar Raw's committee. Next paragraph. Even the election committee constituted by this court to conduct the SCBA election in the year 2025 has also made its independent recommendations. All such recommendations have been put together and collated in a comparative chart that has been placed on record by the SCBA. Next paragraph. Some of those suggestions which we propose to accept at the outset so like this, while those suggestions stroke recommendations will be examined by us independently, will be examined by us separately, and a comprehensive order to that effect shall be passed, we deem it appropriate to issue the following interim directions. We deem it appropriate to issue today the following interim directions. One, it is a matter of record that election of the office bearers stroke executive members of the SCBA in the year 2025 was disputed through some petitions, and as a result to the order of calculation of votes, the results were finally declared in July 2025.
19th.
The elected members assumed office on 19th July 2025.
like 3-4 days thereafter.
2025. We therefore see no reason to curtail the term of the elected members stroke office bearers, and consequently it is held that the next election for the year 2026 shall be held on or before 31st July 2026.
No, it will have to be, Lord, court reopens on 13th.
Lordship, may I just pass on the orders?
Court reopens on 13th of July, so it will have to be second week of August. 15th August.
Will be held before the election will be held and the results will be declared before 31st July.
31st August, because 13th July is only reopening, so election committee will constitute immediately. Thereafter, then 21 days is to be given. 15th August should be all right, Lord.
इसकी मर्जी हाँ हाँ हाँ
21 days time is required.
Otherwise, make an effort for 31st July.
Problem is, Lord, 21 days will be required after the election.
Lordship, it is before they complete their tenure. According to them, it is 19 July.
So first week we'll notify the election committee, and I'm saying 10th August should be good enough.
Lordship, it cannot be at the, that way it can be done in May also. It has to be the day, the full, what they are saying logically is when the entire committee was constituted, that was 19th of July. So election should be declared on 20th of July, Your Lord.
Practical problem, madam, that time period. Minimum
21 days.
Lordship, process has to start, the voters list has to be published.
We are doing, coming.
Yes.
Wait
Lordship,
some time. We are
Lordship, may I just point out one more thing?
Vacation, your
Lordship, BD Kaushik judgment.
first, only the term will expire by 31st July 2026. Only term will expire by 31st July 2026. Next one. The voter list shall be finalized as on 29th May 2026. All those eligible voters, all those voters who are eligible as on 29th May 2026 shall be entitled to be included in the voter list. Next paragraph. The election schedule shall be notified.
21 days after that is good enough.
Lordship, it cannot be. It is his making his own
He has
rule.
already said last 2 years,
Lordship
he
is-
was not ready to hold an election. That is why your Lordship had to intervene. We have already
Lordship,
said
it
so
is
in
an
our-
outgoing committee like every year, your
let
Lordship,
it not,
we take Lordship's time. Every time there's an election, every committee that I'm seeing from 2024
we have
onwards,
already
they want to stretch their tenure. How can they? They are stretching their tenure on their own. Lordship, they will so to they can make it 2 years also then. Then they'll make it 2 years. Lordship, the voters list will be as per the subscription. So
No.
Notified by the election committee.
By us, by the
Lordship,
EC.
which has to be constituted. which
Every
will
year
be
does it not.
constituted
Last
in
2 years
May.
they were not doing it. So we will do it in the reopening week and
No,
21 days thereafter.
No, Lordship, why? They have the entire May. Yes, it should be appointed next week so that they go ahead with the voters list.
Your Lordship, the executive committee appoints an election committee.
And they
that
do.
election committee takes over and then elections are conducted.
So we will do that in the
Sorry,
reopening
Lord.
week.
It is the executive committee. Executive committee of SCPA appoints the election committee.
Do it in the reopening week and then.
Lordship, it's not.
The executive committee of the SCBA shall notify the election committee on 29th May 2026. Next paragraph. The election committee.
31st May, the courts are closing.
On everything you will put your objection.
No,
There has to be an end of
I'm
this.
only requesting, Your Lordship. I can only request.
For the order.
Doing something as if you are fighting for the US presidency. How that? क्या लिखा था भैया भूल गए 29th May 2026. The notified election, the election committee shall notify the election schedule on 13th July 2026. That is the day
Monday.
when the
Court reopens.
court shall open.
Yes.
Immediate after the partial working day.
That's right.
Partial working day. The next, the election shall be conducted The election shall be
They
completed
take
in all
21
respects.
days, Lord, so it will have to be first, second, whatever.
The,
Fifth up.
the election committee shall ensure that the election is held and the results are declared. That all the election, the entire election process is complete and the results are declared by which date comes in?
5th of August.
5th of August, 30th, 1st of.
Second, third, and
Mhm.
5th or 6th will
between, executive committee will take.
Giving them some elbow room.
Some element.
So we can say
2 days.
Between third and fifth August.
3rd April. Perfect. That is what we had proposed also.
7th.
2020,
उस समय होगा, उसी में आएगा।
the
पहले हो जाएगा।
newly elected executive committee will take over on 7th August 2026. Is it all right?
Yes.
Lordship, may I just point
Your
out,
Lordship,
BT
I
Kaushik
want-
judgment is 26th of September 2011, and I passed that order. That was in IA, which is in July 2012. I passed those orders, Your Lordship. So main BT Kaushik judgment is 26th of September 2000.
Your Lordship, I'm asking for
Just a minute.
represent.
That you want us to secretary or vice president?
Your Lordship, Vice President or the President, Your Lordship. 75 years has been passed, Your Lordship. We don't have a
I
precedent.
don't think that
Your Lordship, Your Lordship,
Bar itself will never do it. So it has to be.
Your Lordship, it is a matter of level playing the field, Your Lordship.
Not do it.
Playing the level.
We are so thankful to the bar.
Yes, Your Lordship.
Bar will accept it, whatever your Lordship says.
They have never opposed us.
Yes, yes.
Yes.
You see, madam, please appreciate the entire country you have led by example.
Yes, Your Lordship.
Talking of Supreme Court bar, the entire nation you have led by example.
Yes, Your Lordship.
When traveling a lot, when go to in remote districts, the bar association, suddenly you find women office bearers.
Yes.
Only because they say Supreme Court.
Yes, Your Lordship. That's a strong message
Lord-
has been
that
gone to
Lordship-
Your Lordship. Your Lordship,
Become the leader.
let us,
Lordship, that-
let us have Your Lordship this time, Your Lordship. President or
Already in the minutes
that's
now. That is already in
let's
the
have an
minutes.
inclusive bar, Your Lordship.
Lordship, that is decided.
Your Lordship, that's
that
all
is
my,
decided. Lordship, that
Your
is
Lordship,
decided
let's
in the
have Your
minutes.
Lordship a reservation in the post
let it be
of
secretary
President or the Vice President. Last time it was Secretary. So
Upon
let
being
it have,
persuaded- Upon being persuaded by us, the Supreme Court Bar Association has graciously accepted our suggestion that the office of Vice President of the.
No, secretary.
No, Lordship, no.
Your Lordship, Vice President, Your Lordship. Last time it was Secretary.
Secretary is the
Lordship,
Your Lordship, last time it was, Your Lordship, we have to really, Your Lordship,
is the more of a.
Lordship with the.
Your Lordship, Vice President, Your Lordship. Your Lordship, let's have a senior,
Secretary was Lordship Secretary.
last time it was Secretary, Your Lordship.
No, Vice President भी क्यों?
Secretary is.
I just
Your Lordship, Secretary has
Lordship,
always been elected, Your Lordship.
1 year it was Treasurer, the other year it was Secretary.
Your
Now
Lordship,
this
Vice President.
Eh?
See, there should be progression.
अरे हमारे भाई हम हमारे होते एक वाइस प्रेसिडेंट भी देख लेते.
President or Vice President, Your Lordship. President, Your Lordship, let us 75 years been passed. We have no, none of, I mean,
Lordship, there are 2 seats
this
which
is
are
the
reserved
highest
for
bar
DD
of the
executive.
association, Your Lordship.
Procedure.
Supreme
My
Court.
lords, if I can,
Lordship, let there be
We-
2 posts for
let
DD
the-
executive.
my lords, if I can plead on behalf of the women advocates of Supreme Court, my lords. If my lords allow me to plead on behalf of the women advocates of Supreme Court. Now this is high. If I'm audible to my
The
lords.
association as a female.
That the post of vice president shall
Lords,
be
if I'm audible to my lords.
exclusively earmarked for women members of the bar, in addition to their representation in the executive committee, as per the previous order dated so and so.
My lords, if I can be heard by my lords.
Other forms, a separate comprehensive order shall be passed. You should be happy now, you should be. भाई सुने नहीं सर पा रहे.
My lords can hear me if I can make a submission, my lords.
Order for chief, I can show in draft order.
Supreme Court, there are posts reserved for lady executive members. So, no, in addition to, I am saying in addition to 30%, let there be 2 more posts, but not an office bearer, vice president, president, secretary is there, treasurer was there, we were happy with that. But lordship, this way, lordship,
An urgent request.
lordship, this way it is going to be.
We are deeply obliged, your lordship.
May I make an
Lordship, item 59 has been dismissed simpliciter.
With less than 30%, that is our order. If in the entire country, up to Leh Ladakh, the laws, the members have agreed, and you want us now. Thank you.
Wait for it.
Not president, only vice president. Only vice
President, it should be president post, my lords. But this time it should be president post.
Lordship, what I am on is the capacity of SCBA should be increased.
Let us see. After 2-3 years, then women members will be quite in a position to contest election for the presidency also.
Item,
May I make an urgent request?
item 59 has been dismissed simpliciter, my lords. I want it to be dismissed as withdrawn kindly. Item 59, it has been dismissed simpliciter. Let it be dismissed as withdrawn.
Millard, may I make an urgent request? Millard, may I make a request?
The separate order,
Millard,
Lord, the separate order should come.
may I make a request, Millard?
Lordship, may I make a, lordship,
Forms also can happen.
Social point, a little bit in depth.
lordship in,
Do it in this side of the. So that
lordship
it will be
in,
implemented.
Just a minute. We cannot impose. Just a minute, sir.
No, corruption also there is a recommendation. Which we accept.
Campaign outside.
Yes.
There is a code of conduct recommendation.
Leave something for the bar.
And that is also a recommendation by Justice
Code of
Nageshwar Rao.
conduct recommended. We will definitely.
Yes,
apply.
absolutely. Yes.
That will definitely apply. There are some other conditions.
Yes.
Where we have to just evaluate what
balance.
is the impact.
Yes, your
I
lordship.
don't want such stringent conditions which may deprive unnecessarily from.
Yes, your lordship. I'm deeply obliged, your lordship.
But at the same time, we don't want non-professional or.
Yes, your lordship.
person.
Yes.
lordship, may I make a request? Lordship,
May I make a request?
lordship,
Millard, this is an.
Saying something.
Millard, may I make a request?
lordship,
Millard, yes. Millard, this is a matter listed.
lordship, the guidelines.
My lords was pleased to recuse himself. Lord, the urgency, he has given us the liberty to make a mention before my lord, the Honorable the Chief Justice. The urgency, my lord, if I am a government distribution company, tomorrow is the trigger date when my power access will be totally cut off from open sources, which would lead to unprecedented power cuts in the state of Maharashtra, my lord.
No, what happened to Justice?
Justice Narasimha was pleased to recuse from hearing this matter today. This was listed at item 8 today before Justice Narasimha. My lord recused himself for whatever difficulty. He gave us a liberty to make a mention before my lord the Chief Justice. My lord, the trigger date is tomorrow, 12 AM tonight. If it can be taken up.
I can't promise, but let me examine what can be done.
Not only one last request.
The urgency is
We understand urgency, but will it be possible tomorrow or on Thursday? That is the only thing to be discussed.
Very well.
Not only,
But by Thursday, we will provide you hearing.
Very well.
not only once last, Lord.
Lordship, a last request, Your Lordship, if the rules can be amended for that, whether with GBM or without GBM, but let the rules be amended because the rule book says something.
Lord, the reform.
Your Lordship, let the ACBA rules be amended. They should amend, and for that, they should take the views of the general ACBA members.
Request is let.
So let them, because there's been so many reforms in between, Your Lordship, 18A. Then there's also a 4-year cap. So for everything, it needs an amendment, Your Lordship. It cannot be just by way of.
Whatever the Supreme Court on judicial side with the support.
Lordship, absolutely.
And in deliberation after with a collaborative approach, whatever reforms we have made, your rules should immediately.
Actually, yes.
Yes, Your Lordship.
That is the first.
Lordship, I'm only requesting.
Recommendation of Justice
Let them constitute a
The rule
committee for
doesn't
amending the rule.
That comprehensive order, your lordships can indicate that also, that the rule should be.
Lordship, the temporary member may be included in this, Your Lordship.
Can come before 20.